Hello, Chloe.
Hi.
Hi. Yeah, how are you doing? Yeah, can you hear me?
Yes, I can hear you.
Yeah. So,
You know it's on YouTube now?
yes, we broadcast it live now in the YouTube.
Okay. Did you get my email?
Yeah, I checked the email and I sent two invitations to Salah.
Okay, it's asking him to sign in. He just needs to make an account, right?
Yes, yeah. Because I saw him initially log in during our test session, and then he logged out.
Honestly, I can't remember. I am on Zoom almost every day, a couple of times. I don't know why this is taking that long time.
No, Faten, we can't hear you.
Because we enable interpretation mode. So, فاتن. لأنه حاليا المود تبع الترجمة شغال، فلازم انتقل على قناتك العربية عشان أقدر أتكلم معك دايركت. أنا سامعك. إذا حولت على القناة الإنجليزية أنا وكلوي ممكن نسمعك.
Oh, she's on. Okay, I'll go on the English channel. Hi, Faten. Good. We can hear you now. So you don't to go on the English channel. So when your class is an interpreter, only people in that channel will be able to hear you. Okay. Is that okay?
Yeah, I think the security team not allowing the Zoom there or something.
Pattern, the problem is when I think I discussed it with you all yesterday that IT blocks the version of Zoom that we need. So you'll need to contact IT to download the new version onto your computer.
Are you sitting right now in front of the computer? Can you give me your employee ID? Can you accept my request?
Okay, we should have Salah joining us to do a test run soon. It still only says we have 3 participants.
ممكن تعملي ابروف.
Ibrahim?
Yes.
Salah has just messaged me to say he's trying to enter the meeting, but it's saying that as the meeting has not started yet, he's not able to enter. Does that mean he's being set up as a attendee rather than panelist?
No, I sent him from the panelist console, but let me double check it again.
Okay.
عندك الرابط ممكن تدخل عليه بعدين. لا الرابط انا كان بعت لك اياه، اخر رابط دخلت عليه. خلي الساين روح من هناك ودايركت كليك عليه. You don't need to register. The last link you received, you just click on it. It will take you directly to this one. Just join. Click join. Okay. Okay. Lunch meeting, yes. Yes. Chloe, I will send you the invitation that been sent to Mr. Salah. Can you forward it for him? عشان كده أنا قلت لك ادخلي بالرابط اللي جاك آخر مرة. Okay, let's minimize this one. أنت مش دخلت من هالرابط صح؟ أيوه هذا. طب تقدر اطلع من التليفون وادخلي تاني مرة على عشان على الرابط هذا. اوكي. الو. هلا. وصلت ياك الايميل الدوام؟ بسوي لك ريسنت مرة ثانية. لا، كل واحد يا ايميل قبل ساعة ريمايندر. إذا بتخلوا الحين اوكي عادي. هذا ترى شكل ايميل. اوكي ارسلت لك اياه. ايه دخل واحد وباقي الثاني هذا شو اسمه لكن لا انا معاها بس قاعد تسوي لوجن. موجودة والله. لا بعدنا، ما هو ليه ما يستارت بعدين بيشتغل على هذا. اوكي يلا سلام. يس عاصف. Yes, yes, sir. Yeah, doing well, alhamdulillah. You? Yeah, we're just waiting for 5 minutes to join us. Yeah, Kalo is online. فاتن. خلاص أمورك تمام. معانا كمان عاصف اوريدي جاهز. So you just you can chat me in chat window if you want to tell me anything. Okay.
اول مره ثالث قضايا
So Chloe, I think Mr. Ahmed Marzouki already online.
Yeah.
We are 3 minutes to go.
Yeah. Should we start the webinar?
Okay. And we will start right now. Okay. Ready? Okay. It's live now.
You take photo for him? فاتن استاذة فاتن وين زينة وايد زينة.
لا على الكرسي من ورا ناقصة. يا
Take the camera a little bit down.
عندك كاميرا تستمر شحال؟ ها؟ تبغى فيديو بعد ولا؟
وين الكتاب؟ وين الكلمات الحين؟ عشان يمين شوي ورا السماعات.
وين تبغى؟
لا الكلام.
وين اوديه؟
فين؟
شوف كيف تبغى. شوف كيف تبغى. ما اقدر.
حطيهم.
We will just wait a few more minutes just to allow people to attend. Yes, we can hear you great. Thank you.
مشكلة الصورة اللي اوكي. هذا موجود.
We're just waiting for a few more people.
How are you, Mrs. Clue?
I'm good, thank you. Salam alaikum. How are
Thank
you?
you.
How's everybody? Hi, Ms. Lou.
Hi, I'm good, thank you. How are you?
Fine, thanks.
Thank you for joining us.
Welcome.
We're just waiting for a few more speakers and then we can start.
بتصير بعدين يبقى الصورة عليه.
Thank you.
Okay, let's get started, and the rest can join us throughout. So, good morning, afternoon, and evening. I hope you're all safe and well, and would like to welcome you to this webinar, An Insight into the World of Sports Law. On behalf of everybody at Abu Dhabi Judicial Department, we are honoured to have you here with us today. In relation to the technical aspects, we recommend that you have the latest version of Zoom installed to enable the translation function. I think it's 5.4 at least that you should have. You should then go to the bottom of your screen and you'll see the icon that says interpretation. Now you need to select this button, interpretation button, and click on your preferred language. So either Arabic or English. And then this will enable you to listen to the webinar fluently in the chosen language, as some speakers will be talking in English and others in Arabic. If you have any questions, please put them in the question and answer chat box. They will be answered at the end of the webinar. Please also kindly make sure that you are muted at all times. It is now my pleasure to introduce you to His Excellency Ahmed Al-Mazuri, Director of Support and Internal Operations at Abu Dhabi Judicial Department.
بسم الله الرحمن الرحيم. سعادة الأخ ضرار بن هول الفلاسي، نائب رئيس مركز الإمارات للتحكيم الرياضي. سعادة الأخ عارف العواني، الأمين العام لمجلس ابوظبي الرياضي. السادة المستشارين، السادة والسيدات الحضور الكريم، السلام عليكم ورحمة الله وبركاته. يسعدني أن أرحب بكم جميعا في هذه الندوة الافتراضية التي تنعقد عن بعد تنفيذا للتدابير والإجراءات الاحترازية التي أقرتها حكومتنا الرشيدة بالتزامن بالتباعد الاجتماعي الموصبة من قبل منظمة الصحة العالمية لمواجهة جائحة فيروس كورونا المستجد. كما يسعدني أن أنقل لكم تحيات سعادة المستشار يوسف سعيد العبري، وكيل دائرة القضاء، الذي يتمنى لنا جميعا كل التوفيق والنجاح في هذه الندوة الافتراضية. كنا نتمنى أن يكون الترحيب بكم جميعا في دولة الإمارات العربية المتحدة وعاصمتها أبوظبي، ولكن شاءت الظروف أن يكون لقاءنا بكم عن بعد، عاملين أن يكون اللقاء القادم بإذن الله تعالى في مدينتنا وعاصمتنا الجميلة. وتنعقد هذه الندوة الافتراضية كأحد الأنشطة والفعاليات التي يعقدها فرع محكمة التحكيم الرياضي كاس في مدينتنا ودولتنا دولة الإمارات العربية المتحدة وعاصمتها أبوظبي، والذي تم افتتاحه في منتصف شهر مايو عام 2012 تنفيذا للاتفاقية المبرمة بين دائرة القضاء والمجلس الدولي للتحكيم الرياضي في بداية العام 2012. ومن خلال هذا المقر، والذي يعتبر الأول من نوعه لمحكمة التحكيم الرياضي في منطقة الشرق الأوسط وشمال أفريقيا، المأمول أن يسهم المركز في سرعة فض النزاعات الرياضية وفي تحقيق العدالة المأمولة في النشاط الرياضي على المستويات كافة، سواء كانت في الدورات الأولمبية أو القارية أو البطولات العالمية أو التعاقدات بين الأندية واللاعبين أو في قضايا المنشطات. ومن هذا المنبر وفي هذه المناسبة الرياضية الافتراضية أود أن أحيطكم علما بعزم فرع محكمة التحكيم الرياضي على عقد الدورات التدريبية والبرامج اللازمة لتأهيل المحامين والباحثين القانونيين وغيرهم من المهتمين بالشأن الرياضي وتزويدهم بالمعارف ذات الصلة بإجراءات المحكمة الرياضية والقوانين المنظمة للرياضة والمنازعات الرياضية. كذلك أود أن أؤكد لكم أن هذه الفعالية تأتي في إطار خطة ومنهجية دائمة ومستمرة لتنظيم المؤتمرات والمنتديات والفعاليات الأخرى ذات الصلة بتطوير ونشر الوعي القانوني الرياضي في منطقة الخليج العربي بصفة خاصة ومنطقة الشرق الأوسط وشمال أفريقيا بوجه عام. أتمنى لكم ندوة موفقة وكل ثقة بنجاح هذه الفعالية بتضمنها من شخصيات قانونية ورياضية مشهود لها على مستوى العالم بالأجمع بالتميز والمنهجية. وأرد وأكرر ويسعدني مرة أخرى أن أرحب بكم في دائرة القضاء ابوظبي، متمنيا لكم مزيد من التوفيق والنجاح، وشكرا لكم والسلام عليكم ورحمة الله وبركاته.
Thank you so much, Ahmed Al-Mazuri. I'm now going to welcome His Excellency Saeed Abdul Ghaffar, Secretary General of the General Authority for Sports.
المستشار الأخ الأستاذ عبد الغفار اعتذر لظرف صحي، ننقل الكلمة للأخ ضرار أستاذ كولين.
Okay, no problem. We will now hear from His Excellency Daira Balhol Al-Falasi. Welcome. He is the Vice Chairman of Emirates Sports Arbitration Center.
Thank you, Khan. It's my pleasure to be here with you. If you may allow me, I will speak in Arabic because it's mandate. I have to speak in Arabic. السلام عليكم ورحمة الله وبركاته. سعيد بتواجدي معاكم في هذا المنتدى. شكرا أخويا أحمد على التقديم، وشكرا على التقديم الرائع من قبلك، يعني ما قصرتي. أنا أعتقد نحن الآن قدام أمام يمكن ليست بالمشكلة الكبيرة، ولكن نحن الحمد لله في مركز الإمارات للتحكيم يمكن القانون صادر في 16/6/2016 ولكن لم يفعل إلا في شهر 6/2020 في ظل ظروف. في ظل هذا الحمد لله تم إنجاز جزء كبير منها، والآن بدأ المركز يباشر عمله. نحن قبل ما نبتدي كنا ركزنا على إجراء استطلاع للرأي وقياس مدى مفهوم ثقافة التحكيم في الجهات العاملة في النشاط الإماراتي. نحن عندنا ملاحظات، يعني قبل ما تبتدي في موضوع التحكيم وتدخل مباشرة في موضوع القضايا، إذا ما كانت عندك النولج عن مدى الوعي بهذا المفهوم، أعتقد نحن كنا بنواجه مشكلة. الحمد لله هناك وعي ولكن نحن ما زلنا في بداية الطريق، ما زلنا أمام مفهوم جديد لدى الرأي العام. هناك اختلاف لدى بعض الآراء في الرياضة. نحن القانون نص 16/2016 على أن نحن الجهة الوحيدة في الدولة التي تبت في موضوع المنازعات الرياضية المحلية، إذا كانت وطنية مهما كانت، إذا هي منازعة رياضية نحن اللي نبت فيها. ولكن هاي المشكلة الحمد لله انحلت الآن، وأصبح الجميع يدرك هذا الشيء ويدرك وين مضى. أفضل مثال يمكن حدث في موضوع الشطرنج، عندما اشتكى أحد الأندية في الاتحاد الدولي للشطرنج، والاتحاد الدولي للشطرنج أرسل رسالة إلى اللجنة الأولمبية. اللجنة الأولمبية شرحت للاتحاد الدولي أن نحن لدينا مركز الإمارات للتحكيم، وهو صادر بقانون، ويمكن هذه ميزة تخدم المركز وتعطيه دافع قوي، أن مركز الإمارات للتحكيم الرياضي صدر بمرسوم من رئيس الدولة، وقانون هذا يعطيه قوة، في حين بقية المراكز خلينا نقول إذا أخذنا على سبيل المثال في الشرق الأوسط صادرة من الهيئة أو قرار أو شيء، لكن هذا صادر بقانون ويعطيه قوة ودافع يمكن أكثر. بعد الرسالة هاي رئيس الاتحاد الشطرنج اعتذر أن ارتكب خطأ، لأن القضية موجودة هنا، واعتذر على الموضوع، والآن يتم البت في هذه القضايا. المهم جدا واللي أنا حابة أوضحه أن نحن في ظل ظروف نجحنا في هالشيء. الآن بدأت الممارسات لدى الجميع في الإمارات. نحن إذا ما خلقنا ثقافة لفهم التحكيم، على سبيل المثال نحن أكدنا على أنه يجب على الاتحادات والأندية أن يكون عندهم نظام أساسي واضح نحن سنحتكم عليه. إذا لم يكن لديك نظام أساسي واضح فنحن من سنبت فيه عن طريق مركز التحكيم. الحمد لله يمكن حاليا ما يقارب من 13 قضية، بالرغم من يعني إذا أنت تحسب من 6 إلى خلينا نقول شهر، من 6 إلى شهر سبتمبر أو أكتوبر حتى، هذا كان يعني مجرد إعداد، ولازم تحط لك استراتيجية، لازم تحط لك هيكل تنظيمي، لازم تبحث عن كوادر. ولكن الآن المركز والحمد لله، لأن نحن بدينا بطريقة صح، بدينا بقياس الرأي، مدى قابلية المجتمع. هذا المجتمع الآن بعد قرار، أول قرار يعني صدر من، طبعا نحن أعضاء مجلس إدارة، ليس لنا أي دخل في القرارات التحكيمية اللي تصدر من الغرف التحكيمية الابتدائية والاستئناف. ففي قرار صدر أوقف الانتخابات في اتحاد الطائرة إلى حين البت. هذا كان يمكن إحدى القرارات القوية التي أكسبت المركز ثقة في الرياضة في الإمارات، وبدأ هناك أصبح هو الملجأ لحل المنازعات. أيضا تم إدراج كافة اللاعبين في عقودهم الجديدة أن مركز التحكيم، مركز الإمارات للتحكيم الرياضي هو المسؤول عن هذه المنازعات. وإن شاء الله أنا أتوقع في غضون سنة سيكون هناك استجابة، لأن نحن من ضمن الخطط مالنا أن يتم التواصل مع الكاس ويتم تأهيل الأكبر عدد من المحكمين والموافقين. يمكن نحن حطينا مبدأ جديد عندنا نحن، إذا نجحنا في التوفيق قبل التحكيم، بالرغم أن يعني التحكيم هو السورس مال الانكم مالنا، لكن نحن التارجت مالنا أن نحن نحل قبل اللجوء إلى المحاكم، وكان هذا هدف قدامنا. والهدف الثاني هو أن يتحول مركز الإمارات للتحكيم إلى مركز للثقة يجذب القضايا من المناطق المحيطة به. شغالين على أن نحن حتى القضايا تكون افتراضية، وإن شاء الله قريبا الموقع سيكون شغال ونبتدي نتلقى قضايا من خارج الدولة أيضا. شكرا. أتمنى إذا في أسئلة بعد أنا حاضر يعني.
Thank you so much. That was really interesting. I just want to reiterate for those of you that have just joined us, if you go to the bottom of your screen, you will see an interpretation option. Please click on that and then select whether you wish to listen to the webinar in English or Arabic, so you can receive the appropriate translation. Now it is my pleasure to welcome His Excellency Arif Hamad Alawani, Secretary General of Abu Dhabi Sports Council.
Thank you. السلام عليكم ورحمة الله وبركاته. آسفين على التأخير، احنا كنا في لينك ثاني، لكن تحصل إن شاء الله أن نستعجل إليكم. بسم الله الرحمن الرحيم. الحضور الكريم، السلام عليكم ورحمة الله وبركاته. بداية يطيب لي أن أنقل لكم تحيات سمو الشيخ نهيان بن زايد آل نهيان رئيس مجلس ابوظبي الرياضي، الذي يوليه بالتأكيد اهتمام كبير لاستضافة تنظيم ابوظبي لأهم الفعاليات والملتقيات والمؤتمرات الرياضية العالمية الثرية بالمكتسبات والتجارب المميزة، انطلاقا من حرص القيادة الرشيدة على دعم الحركة الرياضية بأهم الممارسات المتطورة. كما نرحب بجميع المشاركين في أعمال المنتدى اللي هي النظرة في عالم القانون الرياضي، اللي تنظمها مشكورة دائرة القضاء وفرع محكمة التحكيم الرياضي بالدائرة بصفة افتراضية، مما يؤكد الحرص الكبير والاهتمام على مواصلة تقديم نماذج ثرية للوسط الرياضي والقانوني في المنطقة. الحضور الكريم، عقد مثل هذه الملتقيات المهمة يساهم بشكل كبير في تطوير التجارب الاحترافية للمنظومة الرياضية في ابوظبي وفي دولة الإمارات، وبالتأكيد في منطقة الشرق الأوسط كاملة وآسيا ويعزز مساره التنموي اللي وصل لمراحل متقدمة حتى غدت وجهة مميزة وجاذبة لصانع القرار الرياضي الدولي ونجوم العالم في كافة الرياضات. كما يمثل عقد المنتدى امتداد مميز للتجارب الناجحة اللي شهدتها ابوظبي في وقت سابق، عندما استضفنا في عام 2016 المؤتمر السنوي الرابع للجمعية الدولية لمحامي كرة القدم للمرة الأولى من نوعها على صعيد منطقة الشرق الأوسط بمشاركة 30 خبير قانوني وغيرها من الندوات والمؤتمرات المهمة اللي أثمرت عن تعزيز مكانة ابوظبي وريادتها العالمية ليس على مستوى احتضان الفعاليات الرياضية بس بل على امتداد يشمل كافة محاور صناعة القرار والتشريع وصياغة التشريعات واللوائح اللي تخدم الحركة الرياضية الدولية. نفتخر في ابوظبي باحتضان أول مقر للتحكيم الرياضي خارج سويسرا بالتأكيد في ظل دعم وتوجيهات سمو الشيخ منصور بن زايد آل نهيان نائب رئيس مجلس الوزراء وزير شؤون الرئاسة رئيس دائرة القضاء. ونؤكد لكم دعم القيادة الرشيدة اللي أثمر عن تطور كبير في مجال القانون الرياضي وسهم بإثراء منظومة عمل الاتحادات والمؤسسات الرياضية وانعكس بشكل لافت على كافة الاتحادات في الدولة وعلى أندية ابوظبي تحديدا عندما قمنا بتطوير اللوائح والقوانين بما يوازي المكانة الاحترافية اللي تتمتع بها، وقدمنا نموذج مميز في تعاملاتنا المؤسسية وشملنا ولله الحمد جميع الرياضات وصولا حتى للأندية المتخصصة بالأنشطة النوعية والمسابقات التراثية برفع درجات التقاضي بحيث أنها تكون متوافقة مع جميع النظم القضائية الرياضية. الحضور الكريم، في الختام نشيد بالدور البارز اللي تلعبه مثل المؤتمرات والندوات المهمة بمشاركة بارزة من نخبة المختصين وأصحاب الشأن في قوانين التحكيم الرياضي، ونؤكد لكم أن مجلس ابوظبي الرياضي يحرص على دعم هالملتقيات الثرية ونتطلع باستمرار الشراكات الدولية المميزة مع مختلف الاتحادات والمؤسسات الرياضية العالمية اللي من شأنها تسهم بدعم مسيرتنا في التطوير والارتقاء وتفتح آفاق جديدة تستشرف من خلالها رياضة الإمارات التميز والاحترافية لتحقيق غاياتها. والسلام عليكم ورحمة الله وبركاته.
Thank you very much. We're now going to move on to our topics. But again, I'm sorry to repeat myself, just we do have some more attendees that have joined us. For the translation option, if you've just joined us, please go to the bottom of your screen, press the interpretation button, and then select either English or Arabic, whatever your preferred choice of language is. So, the first speaker is Tairan Gunawadina. He is an Australian qualified lawyer and holds a master's in international sports law from ISDE in Madrid. He works in the sports law team in the London office of Mills & Reeve LLP. His work includes advising players, clubs, unions, and federations on sports regulatory matters. Tairan also has significant expertise in sports arbitration and proceedings before the Court of Arbitration for Sport. He is an arbitrator for UCI and is on the disciplinary panels for England boxing and British gymnastics. He was selected by Who's Who Legal as a leading sports lawyer in 2018, 2019, and 2020. The topic he will speak about is an insight into international sports law. Welcome, Tairan.
Thank you. You can hear me properly?
Yes, thank you.
Thank you. Thanks, everyone. Good morning to everyone listening in. Firstly, thank you very much to the Abu Dhabi Judicial Department for the invitation to speak today. It's a pleasure to speak at this event alongside so many distinguished speakers. So the topic I've been asked to speak about today is called Insight into International Sports Law. It's quite a broad topic, to say the least. You could speak about it for hours, but I've only got 15 minutes. So I'll try to give you a flavor of what international sports law is about. I'm also conscious that you've got some excellent speakers over the next 2 days who will be speaking in detail about various topics within the issue of international sports law. So I'm conscious that I'm not going to try and overlap with what they're likely to speak about. So what is international sports law? Is it a separate identifiable body of law in its own right? Or, for example, contract law or employment law or torts or intellectual property? Or is it an amalgamation of various bodies of law, simply applied in the context of sport? It's not actually the easiest question to answer. And I think there's been dozens of books and thousands of pages written by academics analyzing this issue, including on the concept of lex sportiva and whether such a thing exists. But I'm not an academic, so I'll leave it for people smarter than myself to explain those concepts to you. But what I will do is to try to explain to you from the perspective of a private practice lawyer working in England, what I think of when I hear the phrase international sports law. So is it a separate body of law or a combination of laws put together in the context of sport? I think it's actually both, but ultimately in practice, I don't think it really makes a difference. What matters is that sports law, however you choose to define it, exists. Sports law is employment law and contract law and intellectual property law and torts and all of those bodies of law applied in the context of sport. But sports law also involves specific rules and regulations in sport and also jurisprudence from the Court of Arbitration for Sport. So compared to other areas of law, sports law is relatively new. The rise of sports law over the last sort of 10 to 15 years is largely linked to the growth of the sports industry in that same time. Sport is not only a product of huge social and cultural importance, but for a long time now, it's also been very big business. The amount of money in sport has increased exponentially over the last two decades. TV rights deals are worth billions and player contracts are worth tens of millions. And it was just over 3 years ago that Neymar moved from Barcelona to PSG for a staggering transfer fee of almost €250 million. When there's more money, of course, there are inevitably more legal disputes and lawyers getting involved who challenge the rules. The rules and regulations in sport then need to be amended to take into account these legal challenges. So that cycle in a sense has led to a rapid evolution of what we call sports law over the last couple of decades. This has also coincided with the rise in the public profile of sports disputes. 10 years ago, I think very few people outside those working in the sports industry would have heard of the CAS. You compare that to where we are now, where you've got CAS hearings which are publicly broadcast, like the Sun Yang doping case recently, or cases which draw a significant amount of widespread mainstream media coverage, like the Casta Semenya case against the IAAF recently, or Manchester City's dispute against UEFA, or the ongoing WADA and RUSADA dispute. So in 2020, the average sports fan probably has heard about the CAS and the concept of sports law, even if they don't truly understand the role that it plays in world sport. So the need for international sports law is actually quite apparent when you think about the structure of sport globally. So the governance structure of international sport is generally organized in a top-down pyramid-like model. So at the top of the pyramid are the world governing bodies. So FIFA for football, FIBA for basketball, the IOC for Olympic sports, etc. And below that, you've got national associations responsible for its own territory. But given how interconnected world sport is, decisions made by sports organizations can have an impact on other participants in sport. In football, for example, you can have a player playing for his club side on the weekend, and then a Champions League fixture for his club midweek somewhere else in the same continent, and then playing for his national team somewhere else in the world the following week. All of those tournaments and events are organized by different governing bodies at national, confederation, and international level. So for all of that to work seamlessly, there needs to be a level of coordination and synchronization in the rules and regulations of football worldwide. So the national confederations and international governing bodies can't simply act in isolation, because if they did, the international football ecosystem couldn't function as we know it. Similarly, it'd be untenable if there wasn't an international coordinated approach to anti-doping, for example. It wouldn't make sense for an athlete to receive a 4-year ban in one country if he or she were to take a prohibited substance, but only get a 3-month ban for taking that identical substance in a neighboring country. So in the interest of fairness and having a level playing field in international sport, you need to have some level of equality in rules and regulations. This notion was actually explained quite succinctly by a CAS panel in a case from 2005, Appeals Case 983 and 984, if you're interested in reading it. I'll read out a quote from that panel's award. It said, "The panel considers that sport is naturally a transnational phenomenon. It is not only desirable, but indispensable that regulations referred to the sport at an international level have a uniform and coherent worldwide character. In order to ensure a respect at worldwide level, such a regulation should not be applicable in a different way from one country to another, due to interferences established by a state law or a sporting regulation. The principle of the universality of the application of the FIFA regulations or of any other international federation is a need for the legal rationality, security, and predictability. All the members of the football family are therefore under the same regulations which are published. The uniformity that comes from it tends to assure the equality of treatment between all the addressees of such regulations, independently of the countries from which they are. So the panel made those comments in the context of analyzing a unilateral extension option in an employment contract. But that quote is quite a good explanation of how and why international sports law has taken on such significance in sport over the last 2 decades. So that's sort of a whistle-stop tour as to how international sports law has risen to prominence over the last few decades. But perhaps the best way to give you an insight into what international sports law actually is to give you some practical examples. Take, for example, a Brazilian footballer playing in Spain. So the footballer would sign an employment contract subject to Spanish employment law, as they're based in Spain. If there was a dispute between that player and the club, that dispute, in principle, could be heard by the FIFA Dispute Resolution Chamber in Switzerland. Whilst taking into account the content of the employment contract, the FIFA Dispute Resolution Chamber would apply FIFA regulations when determining that dispute. And those FIFA regulations are subject to Swiss law because FIFA is a Swiss entity. When FIFA renders a decision, that decision can then be appealed to the Court of Arbitration for Sport, which is also based in Switzerland. And disputes at the CAS are subject to the CAS Code, which is a set of arbitration procedural rules, which are also underpinned by Swiss law because the CAS is based in Switzerland. So in that example that I've just given you between a dispute between a Brazilian footballer and a Spanish club, the CAS panel looking at that case would be conducting an international arbitration procedure whilst applying some combination of Spanish law, Swiss law, FIFA regulations, perhaps even some Spanish football regulations, and the CAS Code. And that kind of example that I've given you is not an entirely uncommon dispute that you'd hear at the Court of Arbitration for Sport. Now, you might be wondering, in a scenario like that, how do you know which sporting rules apply or which country's laws apply? As you might expect, that's quite a complex issue. In short, you'd need to analyze the choice of law by the parties to the dispute, for example, in the contract, which is in dispute, the applicable law at the seat of the arbitration, and a variety of other factors to come to a determination as to what the applicable law is. It's not a straightforward exercise, but that's perhaps why you do need international sports lawyers. Aside from that, I think one interesting element of international sports law disputes is that you don't need to be qualified as a lawyer in any particular jurisdiction in order to appear before sports arbitration bodies, such as the CAS, or indeed to even sit as an arbitrator before the CAS. So you often have lawyers and arbitrators from a variety of different jurisdictions, all involved in the same international sports law dispute. To me, that's what makes international sports law such a unique and interesting industry to work in. Each matter can have such an interesting mix of legal issues, and the parties and lawyers involved come from all over the world. I can give you some other practical examples of both international and domestic sports law matters from the work I do at Mills & Reeve. So for example, I work on a large amount of disputes before FIFA and the CAS. And you'll be hearing a presentation specifically about the CAS later on in this conference. So I'm not going to go into this in any particular detail. But what I will say is that matters before the CAS can involve a variety of legal issues in sport, not just employment disputes, but anti-doping matters, selection and eligibility matters, financial fair play, transfer disputes, ethics violations, and so on. So all of those disputes generally involve their own set of unique sporting rules and regulations, and all of that would have an international dimension. Aside from that, I also work on domestic disputes. So these are disputes between football clubs or players, athletes, or federations based solely in the UK. So this would involve, amongst other things, an analysis of English FA regulations, Premier League regulations, EFL, English Football League regulations, and English law. So this is probably a good point to sort of briefly mention the distinction between domestic sports law and international sports law. Domestic sports law, as the name suggests, is sports law in a domestic context. So I'm based in England, so I'll use England as an example. If the parties in a dispute are both English, and the applicable law of any contract between them is English law, or if the applicable sporting regulations which might have been breached are English rules, then the matter would be heard in all likelihood in an English dispute resolution forum. That would be a domestic sports law matter. So the same principle would apply in every other country. If, however, there was an international element to the dispute, so for example, if one of the parties was English, but the other was based in the Middle East, then the matter might be heard in an international dispute resolution forum. So for example, FIFA or the CAS. And international regulations such as the FIFA regulations could apply. And the applicable law might be Swiss law. That then is what we refer to as an international sports law dispute. Aside from that, I act for clubs and players and agents on football transfers during transfer windows. So this would involve the drafting of employment agreements and transfer agreements, which need to abide by FA and Premier League rules, but also FIFA rules. Not to mention the governing law of the contract, which is either English law or Swiss law. And if a work permit is needed for a foreign footballer, you'd also need to apply some immigration law. So as you can imagine, working in sports law requires you to be a bit of a jack of all trades. But as I said before, that's part of what makes working in sports law such an interesting thing. It's worth mentioning, I think, at this point, that although sports law could apply to non-contentious areas of law, such as commercial law and corporate law, in my opinion, when lawyers in the industry hear the phrase international sports law, it's generally in reference to international sports disputes, so the contentious matters. In fact, I think that's reflected in the various topics that you're going to hear about throughout the duration of this conference, which are mainly focused on sports disputes. So that's just a very brief and high-level insight into the world of international sports law. I might just conclude by stating that, in my opinion, international sports law will only continue to become more and more prominent in the future. Sport may have been a recreation in the past, but it's now a highly lucrative business. The stakes involved for all parties, be it economic or reputational, are significant and only getting bigger. Disputes are becoming increasingly political, indeed even geopolitical, and are being reported in mainstream media. In such a landscape, I think international sports law and the lawyers and arbitrators that work in it will have an important role to play to help bring order and justice to the table. So I hope you found this talk interesting. Thank you very much for listening. Enjoy the rest of the conference, and I'll hopefully be able to answer some questions if you have any. Thank you.
Thank you very much, Tairan. That was very, very interesting. Our next topic is going to be spoken about by Salah Al-Obaidli. He is the founder and managing partner of Salah Al-Obaidli & Co. Advocates and Consultants, which is the first law firm in the Middle East with a dedicated sports law practice. He is a member of the executive committee at the International Football Lawyers Association and was previously an arbitrator at the Court of Arbitration for Sport. He has contributed to the drafting of various commercial and sports law regulations in the UAE, including the UAE arbitration law. He represents athletes, clubs, and federations before all sports dispute resolution bodies, both nationally and internationally, including the likes of FIFA and CAS. He will be talking to us today about the legal challenges facing the sporting industry. Welcome, Salah. I think we possibly have some issues. Bear with me 2 seconds. Yeah, I think he's logged out of the call. I'm just going to send him a message, 2 seconds. Okay, sorry, it seems that he's having some technical problems. So what I'm going to do is I'm just going to move on to the next speaker. If Abdul Salim, can you just confirm that you're available to talk?
Hi.
Hi, we can hear you. Okay. So I'm just going to
give me a second. Yeah, just give me about 2 minutes.
Okay.
Okay, sure. Thanks.
Whilst we are waiting, I'm just going to do an introduction. So Salim served as chairman of the Player Status Committee, PSC, of the Football Association of Singapore from 2013 to 2017. In 2017, he was elected to sit in the Appeals Committee and appointed as chairman. He has provided pro bono legal services to the Singapore Disability Sports Council and rendered honorary legal advice to the Singapore National Olympic Council. He serves as a board member for the National Anti-Doping Advisory Board to the Singapore Sports Council and is a member of the Results Management Committee of the Southeast Asian Regional Anti-Doping Organization. He will be addressing the topic football, spectator offences and penalties. And I'd like to welcome him to this webinar.
Thanks, Chloe.
Thanks.
Okay. Disable. Chloe, I need to share the screen. Can you enable it for me?
Sure. If you just go to the bottom of your screen, it should say share screen. If you
I did that a couple of times, but it says that the host has disabled it for me.
Okay, Ibrahim, can you help us with this, please? Can you try again, please, Ursula? There we go.
Okay, I'll do that. Yes, I need to. Yellow bar. So here's it.
فاتن احنا بنسمعك فعلا بس نرجو ان يكون الصوت اعلى درجه بعد اذن حضرتك. اعلي صوتك بس.
Can I start now?
Yes, thank you very much.
Okay, sure, thanks. Okay, good. Well, this evening here, good afternoon to all in the Middle East. To the rest of the world, I'm not sure which part of the world you are in. In Asia, it will probably be in the evening. It's a wet evening in Singapore. It's been raining for the last couple of hours or so. My topic is actually football offences and penalties. Obviously, you know, spectator offences and penalties would differ from country to country. So what I've done is I have taken a selection of mainly in UK, and I've also touched on a bit of other jurisdictions, including Singapore as well. Yeah. So let's move on. I will be covering 5 separate topics because it is quite a wide topic and it covers quite a range because we can go to any part of the world and you know the offenses do differ from jurisdiction to jurisdiction. So the first topic that I'll be covering will be trespassing and interference. Okay, before the enactment of the Football Offences Act of 1991 in the UK, the prosecutors in the UK used to use the more traditional provisions, such as the Offences Against the Person Act of 1861 and offences under the Public Order Act of 1986 to prosecute offenders. However, in 1991, there was the Football Offences Act in the UK, which deals specifically with footballing offences. And in section 2, you will note that throwing of missiles onto the playing area or into the crowd is made an offence, a specific offence. And this is punishable with a fine. Section 3, Section 3 deals with indecent or racist chanting at a football match. That I will deal with a bit later. There is also another offence under Section 4 of the Football Offences Act of 1991, and that is going into the playing area, which we'll deal with later as well. Apart from the Football Offences Act of 1991, there is also the Sporting Events Control of Alcohol Act of 1985. And it is made an offence if you are drunk at a designated sporting event. It is also an offence if you have a flare or firework at any time during the period of sporting event. I think most of us, if we have been watching football in Europe, we do see this quite often, having flares, fireworks, sometimes the fans even throw them to the pitch. At least in the UK, that's an offence. We've got two cases of streakers. In 2005, an ex-professional boxer, Mark Hargraves, he pleaded guilty to pitch encroachment. He was given 3-year football banning order that's under the another provision, and he was also fined $200. More recently, there was in the Champions League final of 2019, the match between Liverpool against Tottenham Hotspur, a model as well as an actress by the name of Kinsley Wolanski, she actually invaded the pitch. You can actually watch her on YouTube. She came from behind the goalpost, ran straight into the pitch, and she was wearing this outfit which she wanted to advertise on behalf of her sponsors. She was fined $15,000 for her efforts in doing that. More recently, there was an incident in France. This was, if I'm not mistaken, in March or April, which involved a pitch invasion during an illegal footballing match in France. Why it is illegal? It's because it happened during the lockdown, right? Because of COVID-19. So there was supposed to be a lockdown, but an illegal local match took place, and the fans got a bit excited, and 400 fans actually invaded the pitch. I unfortunately am not able to tell what the action was taken by the authorities. And in 2017, in a League One match between Bastia and Lyon, the match was abandoned at halftime after home supporters invaded the pitch twice. The Bastia fans kicked balls into the goal, and police arrived at the scene quickly and brought the situation under control. From what I understand, the police also took action against the fans, some of the fans who invaded the pitch. And I also understand from my research that most of them were fined, and some of them were given ban from entering a football pitch in France. That's a follow-up of that incident in Lyon. Okay, I move on to the next topic, and that is football hooliganism, right? This is quite rife and common amongst rival football fans, especially in Europe. One of the saddest incident, and this is an incident which I remember still watching on TV in 1985. It was the European Cup final, as it was known then, between Liverpool and Juventus, and it is an incident which is infamously known as the Heisel Disaster. What happened was hooligans began throwing flares, bottles, and stones across the divide to the opposing fans, and 39 people were killed. UEFA subsequently banned English clubs from European competitions for an indeterminate period. This was later reinstated. So it culminated into a 5-year ban for English clubs. And it was also a ban which was extended worldwide by FIFA. Insofar as the football fans were concerned, 14 Liverpool fans were convicted of manslaughter. They were sentenced to 3 years imprisonment and also a fine. Those were some of the images from the match. More recently, there was a match between Aston Villa against Cardiff City in 2017, and a fight broke out between Cardiff fans and Villa fans, and they ended up throwing bottles and glasses, and 13 football hooligans were imprisoned between 9 months and 3 years, and 9 of them were actually banned from entering any football ground in the UK for a period of 6 years. If you look at the second image which just appeared, that was actually an image of that incident between Aston Villa and Cardiff fans in 2017, just outside a pub. There were also violence in competitions like the European Championship. In 2016 in France, there were fights between English, Russian, and French or Marseille fans. And to disperse the fans, the police had to use tear gas. These were some of the images which were taken. This one too. And I do have a video which I'll just play.
Hi, Salim. And we have no sound on the video, so I wonder if you could just describe to us what's happening.
Oh, okay, sure. Then I'll just stop the video. Okay. I'll just move on. Okay. Okay. There were also violence during the Russian World Cup in 2018. Celebrations turned into chaos with riots and looting as millions of French fans celebrated their team's victory, 4-2 victory against Croatia in the World Cup. More than 500 people were arrested. And again, police had to use tear gas to disperse the crowd. Well, that's just to give a flavor of what happened during the celebrations of French winning the second World Cup. We move on now to something which is, troubling us quite a bit, and that's racism. Racism is a common form of hate speech, and that's somehow made its way into sports, unfortunately. More recently, we have had the use of racism in the form of social media. And in between November 2018 and November 2019, there was an overall increase in abuse coverage towards football players online with social media platforms. And this is just one example. A famous English Premiership player, Wilfred Zaha, who plays for Crystal Palace. In fact, he scored twice yesterday against West Bromwich Albion. He posted this on Twitter, I believe, and he said he woke up with threats sent to him by a 12-year-old boy. Can you believe it? It's a 12-year-old boy. And the boy actually said, "You better not score tomorrow, you black so-and-so, or I'll come to your house dressed as a ghost," right? And this is just one, it's not just one isolated incident. It's been happening quite a bit in across Europe. There's this football player, Japanese football international player, Yuki Nakamura, who quit the Slovakian club because he did not want to receive any more racist abuse. Effectively, the opposing fans used to chant Fukushima, Fukushima, making reference to the nuclear disaster brought on by the March 11 earthquake and tsunami. So he was somehow related to that, and he actually quit the club because of the racial abuse that he received. And there have been other reports of other Southeast Asian players also receiving chants, and they are labeled as terrorists, and they're being told that they smell the curry. I'm not sure if many of you would remember this incident, right? This incident is one which happened, well, some like 30 years ago, involving Eric Cantona and his infamous kick. What I'm gonna do is I'm gonna play this. Okay, let me just play it again, yeah? Oh, yeah. Okay. Because this is where you should watch. As Cantona was walking off to the dressing room, yes. What do I do? Okay, let's move on. So it was a match between Crystal Palace and Man United. what happened was there was an off-the-ball incident involving Cantona and one of the Crystal Palace players, and Cantona was actually given a red card. As he was walking towards the dressing room, a Crystal Palace fan shouted at Cantona, "You go back to France, you French, so-and-so." The racist comments were directed at Cantona, and Cantona, of course, reacted in the best way he knew by leveling a kung fu kick towards that fan. For his troubles, Cantona was fined 2 weeks worth of wages, banned from playing for 9 months, and he was also sentenced to 120 hours of community service. The fan had his season ticket confiscated, and he was also barred from the ground. Okay, this is something which happened in Singapore. During the 2018 World Cup, 31 people were arrested, and it was because they placed illegal bets worth more than $4 million. And in Singapore, under the Remote Gambling Act of 2014, if anyone is convicted of providing unlawful gambling services, they face a jail term of up to 5 years and maximum fine of 200,000. Whilst beyond this, let me tell you something which I witnessed myself. When I was a student, I used to go to like some local matches, and there is this particular stadium called Jalan Besar Stadium, and it is known in local circles to attract a lot of bookies, right? And what these bookies and what some of these fans would do, they, instead of just watching the match and enjoying the match, they would wage on almost everything, right? They would wage on which team would kick off first, which team would get the first corner, which team would score the first goal, who would score the first goal, who would win the game, how many total number of goals would be scored in each game. And if you actually sit down in the stands and observe, you actually see a lot of, a group of people, and they'll be passing money across to each other. So that's an example of football betting, illegal football betting, and it is quite rife in this region, in Singapore and Malaysia. Okay, coming towards the end of my presentation, of course, we now live in a period of pandemic, and COVID-19 has actually changed the way fans watch football. Since March this year, fans have been banned from watching football at the stadiums. In fact, as we speak, over the weekend, Singapore had the Singapore Premier League, and it was the last round of matches. The last games were played on Saturday. In fact, today is the awards night. And as a measure as a measure of things to come, and to prepare for next season, the authorities have actually allowed the Football Association of Singapore to allow 200 fans into the stadiums. So what happened was, the fans had to undergo a swab test, right? And they will only be allowed into the stadium if they pass the swab test. At the same time, they all have to be masked. They have to be social distancing. And at the same time, they are not allowed to chant and sing and all that. So that happened in Singapore. In the UK as well, the authorities and the Premiership had allowed fans to go back into the stadium. I understand that 2,000 fans were allowed into the stadiums last weekend. Unfortunately, there was an incident which happened in Millwall, it was a championship game between Millwall and Derby County, where, as you are aware, there is the observance of Black Lives Matter, and before the start of each match, every player, including officials, would take a knee in respect of that particular movement. And during that match between Millwall and Derby County, the fans actually booed at that particular event, or at that particular observation. So the club actually made an official statement to regret what actually had happened. In the Premiership, if you will notice, all players do have on their right sleeve the words "no room for racism." So how can fans commit offenses if they're not at the stadium? Of course, if they're at the stadium, they can commit offenses. But if they're not at the stadium, offenses can still be committed via social media, right? But if they are at the stadium, they can actually commit offenses by not complying with whatever they are supposed to comply with. For example, not wearing their mask, singing and chanting, not maintaining social distancing. Sorry. So recently, Prime Minister Boris Johnson had actually announced that there will be 3 tiers of fans who will be allowed back into the stadium. As of last weekend, I think he allowed tier 2, which was 2,000 fans. And they would all have to comply with certain regulations as well. In Hong Kong, fans were allowed to watch matches behind closed doors again, but the government actually tightened social distancing measures. I'm not sure whether there's been a change with the 3rd wave of COVID-19 cases in Hong Kong more recently. In the Hungarian Cup final, spectators were allowed to sit 4 seats apart, and temperature checks were actually taken outside the stadium. Compulsory wearing of masks were also made as a rule to ensure that fans could actually enjoy the match without harming each other. In the Netherlands, limited crowds were allowed back into the stadiums, and at least 1.5 meters distance between the fans, and they were refrained from singing and shouting. Germany, as far as I know, was actually the first in Europe to allow fans back into the stadiums. They allowed 20% of the stadium's capacity back, and once a 7-day infection rate in a home city gets above 35% per 100,000 of the population, the game will have to be played without spectators in attendance. And only home fans were allowed, so away fans were not allowed into the stadium. No alcohol was allowed, and it was a ban on standing, so all fans have to be seated and they all have to wear masks. So obviously, if the fans breach any of these requirements, then they would be committing an offense, and most likely they'll be evicted out of the stadiums. In Singapore, a spectator can be subjected to a criminal or civil liability, depending on what the conduct or action he commits. If he commits violence, he can be charged under the penal code. If there is an interference into the field of play, he can also be charged under the penal code. Singapore does not have a football-specific legislation. If he chants racist remarks, he can actually be charged under the Sedition Act. Following on that, if there is harassment and unlawful stalking, there is a more recent legislation called the Protection from Harassment Act, or in short, POHA. If there is riot, it's also dealt with under the penal code. In fact, I recall when I was involved as an official of Tampines Rovers, a local athlete club, I believe it was in 1998, there was actually a riot where both the away fans as well as the home fans, more the home fans invaded the pitch because they were not happy with the result. They were also not happy with the decisions of the referee. And it was chaotic. I mean, being there in the thick of the action, it was actually quite scary, you know, because you never know if you would be targeted. So, you know, the police, that unfortunately, there were not enough police at these matches because we don't usually see that sort of violence. So what we had to do was to escort the players back into the dressing room and make sure they are safe, and let the police do the jobs. In the UK, they've got the football banning order, and that was introduced by the Football Spectators Act of 1989, and it was aimed to stop hooligans causing trouble at football matches, both home and abroad. And any individual subjected to the football banning order is automatically subjected to a club ban from all stadium facilities for a period of the football banning order. With that, I thank you. Chloe, I take it, I can't take any questions, right?
Yeah, if anybody...
أنا آسف جدا آسف للمداخلة بعد إذن حضرتك. يعني أرجو إن يعني من الأستاذة كلو إنها تنبه المحاضرين إلى الوقت، إن الوقت المقرر لكل محاضر هو 15 دقيقة فقط، إنما إحنا كده بقالنا ساعة بنتكلم في موضوع واحد. فأرجو التنبيه على السادة المحاضرين إن كل متحدث له 15 دقيقة. أستاذة كلو بعد إذن حضرتك.
Thank you. No problem. Thank you very much, Salim. That was extremely interesting and good examples used from changes. Change your channel.
Yeah, thanks, Chloe, and I thank you as well as the Abu Dhabi Judicial Department for inviting me, and I wish a successful webinar today and tomorrow.
Thank you so much.
Thanks.
So our next talk is from Dr. Mohammed Samir, and he's actually an advisor in the Judicial Inspection Department at Abu Dhabi Judicial Department. He holds a PhD in criminal law from Cairo University and recently participated in an international sports law event entitled Justice in Sport. He will be talking to us today about the security of sporting establishments and activities. So welcome, Dr. Mohammed.
بشكر حضرتك على المقدمة، وأنا سعيد جدا في تواجدي مع حضراتكم في ظل هذه الكوكبة من نجوم التحكيم الرياضي. الموضوع اللي هتحدث فيه هو تأمين المؤسسات والأنشطة الرياضية، وهو موضوع يتعلق بالقانون الإماراتي. طبعا لا يخفى على حضراتكم أنه الرياضة تشكل أهمية كبرى في حياة الأمم والشعوب. الأهمية دي أهمية اجتماعية وأهمية للإنسان في الحفاظ على جسده، لأن لا يخفى على أحد الفائدة التي تعود على الإنسان من الرياضة. فائدة أخرى هي فائدة اجتماعية، وهي تتصل ببث روح التعايش السلمي والاشتراك في رياضة، فهي تنمي روح الأخوة والمودة والتعايش المشترك بين الشعوب. لكن الرياضة لا يقتصر الفائدة منها على الجانبين الصحي والاجتماعي فقط، وإنما تتجاوز ذلك لتشمل النطاق الاقتصادي، لأنه تؤدي الرياضة إلى يعني في جانبين. الجانب الأول من يمارسون الرياضة عندما يصبحوا نجوم في الرياضة فإنه يعني يحصلون على مبالغ طائلة. أيضا فيما يتعلق بالعائد اللي بيعود على أي دولة من الدول من الفعاليات الرياضية، فمبالغ كبيرة جدا، ويؤدي تنظيم فعالية ما في دولة معينة إلى يعني رواج سياحي كبير، ولا يخفى ما يعود من جراء يعني تنظيم الفعاليات الأولمبية سواء كان كأس العالم أو غير ذلك، فلها أثر كبير على الدول في تحقيق الرواج السياحي، فضلا عن أنه طبعا هذا ما يخص الدولة المضيفة، فضلا عن أنه بس المباريات والفعاليات الرياضية يعود أيضا يعني بالمليارات من جراء بس هذه المباريات الرياضية. قانون، لكن يعني لابد أن هناك يعني حتى تسير الفعاليات على ما يرام ولا يحدث ما يعكر صفوها، فدأبت التشريعات المقارنة على تنظيم القوانين التي تجرم أي إخلال بالأمن أو النظام أثناء الفعاليات الرياضية أو بسببها أو بمناسبتها. ولم يفت المشرع الإماراتي هذا التنظيم التشريعي، فأصدر القانون الاتحادي رقم 8 لسنة 2014 في شأن أمن المنشآت والفعاليات الرياضية. بترتبط الوقائع أو الجرائم بقانون الإجراءات الجنائية من ناحية أنه إذا كان هناك جرائم فالإجراءات الجنائية. على الرغم من الفوائد المتعددة من ممارسة الرياضة، إلا أنها كأي نشاط من الأنشطة الإنسانية قد يقع فيها من الإنسان خروج على القواعد القانونية أو ارتكاب جرائم، كما في استعمال المواد أو الوسائل المنشطة وحيازتها، وإعطاء المواد المنشطة للحيوانات، والتلاعب في نتائج المباريات، والأفعال الفاضحة العلنية، واستخدام الإشارات العنصرية، واستخدام الشعارات السياسية في الملاعب الرياضية، والشغب الجماهيري، وإهانة العلم أو النشيد الوطني أثناء أو بمناسبة فعالية رياضية سواء للدولة المضيفة أو لدولة أجنبية، والسب والقذف الموجه إلى الهيئات الرياضية، وإدخال مشروبات كحولية أو مخدرات أو أسلحة أو ألعاب نارية في المنشآت الرياضية، ورشوة المستخدمين في الاتحادات الرياضية، وتنظيم نشاط رياضي بدون ترخيص، وممارسة مهنة وكيل لاعبين بدون ترخيص، والإهمال في اتخاذ تدابير الوقاية من العنف، وبيع تذاكر المباريات بدون ترخيص أو تزوير هذه التذاكر، وحمل واستعمال الشارات الأولمبية خلافا للقانون. فحتى يتم ضبط هذه الجرائم لابد من وجود قانون للإجراءات الجنائية ينظم التحقيق في هذه الجرائم وإحالتها إلى المحكمة المختصة. الضبطية القضائية الخاصة في الجرائم الرياضية، نجد أنه تلجأ التشريعات الجنائية الخاصة إلى منح بعض موظفيها صفة الضبطية القضائية لما لهم من خبرة في المجال الذي يعملون به، مما ييسر ملاحقة مرتكبي الجرائم وجمع الاستدلالات عن هذه الجرائم وضبط مرتكبيها. ومن أبرز التشريعات الرياضية اللي تناولت هذا الأمر نجد المرسوم بقانون اتحادي رقم 7 لسنة 2008 في شأن الهيئة العامة لرعاية الشباب والرياضة والجهات العاملة، نصت المادة 42 منها على أن يكون الموظفين الذين يصدر بتحديدهم قرار من وزير العدل بالاتفاق مع الرئيس صفة مأموري الضبط القضائي في إثبات ما يقع بالمخالفة لأحكام هذا المرسوم بالقانون. ونجد أيضا المادة الثانية مكرر على 3 من القانون الاتحادي رقم 15 لسنة 2005 في شأن تنظيم المشاركة في سباقات الهجن، والمادة 11 من القانون الاتحادي رقم 7 لسنة 2015 في شأن مكافحة المواد المحظورة في مجال رياضة سباقات الخيل والفروسية. تأمين المنشآت والفعاليات الرياضية، طبعا من الأهمية بمكان تأمين المنشآت والفعاليات الرياضية حتى يمكن ممارسة الرياضة بأمان وبمنأى عن تعكير صفو الفعاليات الرياضية بأحداث شغب أو اقتراف جرائم، وهو ما يتعين معه منع هذه السلوكيات المؤسمة، وفي حالة وقوع هذه الأفعال التصدي لها جدا حدوث أعمال عنف أو ارتكاب جرائم إبان الفعاليات الرياضية. ونجد مثال لذلك اللي حدث في مصر واللي أطلق عليه إعلاميا بمذبحة بورسعيد. والقضية دي تتلخص وقائعها في أنه وجود خلافات سابقة بين جمهور النادي الأهلي والنادي المصري تم في غضون سنة 2009 أقيمت مباراة بين نفس الفريقين باستاد بورسعيد انتهت بالتعادل. وفي غضون سنة 2010 أقيمت بينهم مباراة أخرى انتهت بالتعادل السلبي، وفيها تعدى جمهور النادي الأهلي على رجال الأمن فور وصولهم إلى محطة القطار ببورسعيد، وتم رشق المحطة بالحجارة وتحطيم واجهات المحلات التجارية وتكسير السيارات، إلا أنه تم إعادة هؤلاء إلى محطة القطار وعادوا إلى القاهرة دون حضور المباراة. الخلافات دي ازدادت أيضا عندما تحدد يوم 1/2/2012 موعدا لمباراة كرة القدم بين الفريقين، حتى بدأت حرب كلامية بين ألتراس النادي الأهلي وألتراس النادي المصري على مواقع التواصل الاجتماعي، تناول كلاهما الآخر بالسباب والوعيد والتهديد والإيذاء، واتهم فيها جمهور النادي الأهلي جمهور النادي المصري بالضعف وعدم القدرة على حماية أنفسهم وذويهم، ومنهم من ذكر ذلك على بعض مواقع التواصل الاجتماعي. وبالمثل تم الرد على ذلك من قبل جمهور النادي المصري بعبارات مسيئة وخادشة لحياء الجمهور، وبدلهم النادي المصري بعبارات مماثلة. بل زاد جمهور النادي المصري على ذلك بتوجيه عبارات على بعض المواقع المذكورة يدل منها نية الصقر ونية قتل جماهير النادي الأهلي. ورصدت الأجهزة الأمنية ببورسعيد ذلك الاحتقان والسباب المتبادل بين الجمهور والوعيد والصقر والانتقام الذي تولد في نفوس وجماهير النادي المصري، وظهرت هذه النية واضحة جلية لدى جمهور قبل المباراة التجهيز لهذه الجرائم وأعمال الشغب، وأعدوا لهذا الغرض أسلحة نارية ومفرقعات صاعق كهربائية وجميعها طبعا تستخدم في الاعتداء على الأشخاص. وأعدوا عصي بيضاء تشع نور أخضر عند إضاءتها ليتعرف كل منهما على الآخر اللي هو جمهور النادي المصري. وبعد لحظة الهجوم وتم فعلا الهجوم على الجمهور في المدرج، وتم ارتكاب جرائم قتل وشروع في قتل وسرقة وإتلاف وإحراز أسلحة ومفرقعات. نستطيع القول إنه القانون الاتحادي رقم 8 لسنة 2014 في شأن أمن المنشآت والفعاليات الرياضية هو قانون وقائي وقانون عقابي في ذات الوقت، لأنه نظم بعض الإجراءات التي تحول دون حدوث ثمة خروج على النظام والانضباط الواجب من قبل اللاعبين والجمهور في آن واحد خلال الفعالية الرياضية، ومن باب أولى في حالة ارتكاب جرائم. ومن جهة أخرى فإن هذا القانون أيضا يعاقب في حالة وقوع جريمة كل من تسول له نفسه اقتراف الجريمة. فتضمن الفصل الخامس منه العقوبات، فعرض للوقائع محل التجريم والعقوبات المفروضة لها في المواد من 18 ل 21. اعتبرت المادة 22 استغلال الفعاليات الرياضية في ارتكاب أي جريمة من الجرائم المنصوص عليها ظرف مشدد. كما المادة 24 فقرة 2 أناطت بمجلس الوزراء إصدار لائحة بالمخالفات والغرامات الإدارية المتعلقة بتطبيق أحكام هذا القانون على ألا تزيد قيمة الغرامة على 5000 درهم. إجراءات التحقيق والإثبات في الجرائم الرياضية. المشرع في القانون المذكور اللي هو القانون الاتحادي رقم 8 لسنة 2014 منح شركات الأمن الخاصة السلطة في تأمين المنشآت والفعاليات الرياضية، لكن ليس بالكامل. هي صحيح هي اللي بتؤمن، لكن تحت إشراف مراقب الشرطة. ومراقب الشرطة حسبما عرفته المادة الأولى من هذا القانون بأنه منتسب قوة الشرطة والأمن الذي يتولى الإشراف الأمني على سير أحداث الفعاليات الرياضية. والمادة 6 من هذا القانون ألزمت كل منشأة رياضية أو جهة منظمة يتعين بتعيين ضابط أمن لكل منشأة وفعالية رياضية بعد موافقة الإدارة المحلية بشؤون شركات الأمن الخاصة وفقا للشروط التي تحددها اللائحة التنفيذية. والمادة 7 منحت اختصاصات لضابط أمن المنشأة الرياضية، لأن هناك ضابط أمن للمنشأة الرياضية وضابط أمن للفاعلية الرياضية، ولكل منهم اختصاصه. فيختص ضابط أمن المنشأة الرياضية بالمحافظة على أمن وسلامة القيام بأعمال والحماية وإجراء التفتيش الأمني على الأفراد والمركبات عند نقاط الدخول ومتابعة المواد التي تدخل المنشأة الرياضية بالتنسيق مع مراقب الشرطة. وهذا البند بند هام جدا، إن أنا من خلاله لما بفتش الأفراد والمركبات عند الدخول إقرار هذا الأمر، ده بيحول دون وقوع أحداث شغب أو ارتكاب جرائم، لأنه السبب في الوقائع اللي أنا عرضتها في القضية اللي بيطلق عليها إعلاميا مذبحة بورسعيد إنه كان مع الجمهور أسلحة وأدوات تستخدم في الاعتداء. فإذا تم تجريد الجمهور من هذه الأدوات التي يمكن من خلالها الاعتداء، فده جانب وقائي واضح في هذا القانون، فضلا عن وضع الخطط التفصيلية لعمليات الطوارئ والإخلاء والإجراءات الوقائية من الحرائق وغير ذلك من التدريبات اللازمة بصورة دورية بعد اعتمادها من السلطة المختصة، فضلا عن إعداد سجلات الأمن والسلامة للمنشأة ومراجعة السجلات بالتنسيق مع ضابط أمن الفاعلية ومراقب الشرطة أثناء الفاعلية، وأي اختصاصات أخرى تنص عليها اللائحة التنفيذية. أما المادة 8 من ذات القانون فبينت اختصاصات ضابط أمن الفاعلية الرياضية، وهي التنسيق مع ضابط أمن المنشأة في مباشرة الإجراءات الأمنية لمقر الفاعلية الرياضية والمنافذ والمخارج المؤدية إليها، وتأمين مستلزمات السلامة الضرورية لمقر الفاعلية، دان الملعب من كل ما يشكل خطرا، وتأمين نقاط الوصول في حالات الطوارئ، والمشاركة في تسهيل حركة السير في كافة الطرق المؤدية لمقر الفاعلية. يعني ليس فقط تأمين مكان الفاعلية، لا، ده المناطق المحيطة بالفاعلية والطرق اللي تؤدي إلى الوصول إلى الفاعلية. التنسيق مع كافة الجهات في الفاعلية الرياضية، وذلك لضمان حفظ الأمن وإنجاح الجانب الأمني للفاعلية، والتنسيق خطة الإخلاء والطوارئ مع ضابط أمن المنشأة ومراقب الشرطة، والاختصاصات الأخرى التي تنص عليها اللائحة التنفيذية. المادة 9 ألزمت الاثنين، ألزمت ضابط أمن المنشأة الرياضية وضابط أمن الفاعلية بكافة التعليمات والأوامر الصادرة عن مراقب الشرطة فيما يخص أمن الفاعلية، وعلى مراقب الشرطة مساءلة كل من يخل بالإجراءات الأمن من ضباط المنشأة الرياضية أو الفعالية الرياضية أو عناصر شركات الأمن الخاصة وفقا لما تحدده اللائحة التنفيذية. لأنه مراقب الشرطة بيعطي تعليمات وبيعطي يعني توجيهات عليهم أن يلتزموا بها، سواء ضابط أمن المنشأة أو ضابط أمن الفعالية وشركات الأمن الخاصة اللي بتعمل تحت إدارتهم. ففي حالة التقصير بيوقع جزاء عليهم. في إثبات هذه الجرائم بيتم استخدام تسجيلات الفيديو وأنظمة المراقبة في الإثبات الجنائي. احنا لدينا هنا في دولة الإمارات وخاصة دبي وابوظبي يعني كاميرات مراقبة في معظم الأماكن، يعني 99% من الاماكن فيها كاميرات مراقبه تغطي جميع انحاء كل ابوظبي ودبي، ولهذه الكاميرات دور فاعل في كشف غموض الكثير من الجرائم، لا سيما اذا ما لاحظنا انه الفعاليات الرياضيه غالبا ما يتم بثها بث مباشر وتسجيل وقائعها واحداثها. فهذه التسجيلات يعتمد عليها، ولم تجد المحاكم اي حرج في التعويل على ما ورد بهذه التسجيلات وأنظمة المراقبة، سواء القضاء في دولة الإمارات سواء المحلي أو الاتحادي على السواء. وأيضا محكمة النقد في مصر عولت على الكثير من تسجيلات الفيديو. المحكمة المختصة بنظر الجرائم الرياضية، هناك اعتقاد شائع في مصر وبعض الدول العربية مؤداه انه عدم جواز اللجوء الى القضاء في الجرائم الرياضية، على سند انه الاتحاد الدولي لكرة القدم الفيفا والاتحادات الرياضية الدولية الاخرى تمنع اللجوء الى القضاء للفصل في المنازعات الرياضية ومنها الجرائم الرياضية، وبما تتضمنه من اجراءات واحكام خاصة بهذا الشأن، وتقصر تسوية هذه المنازعات على التحكيم الرياضي. لكن هذا غير صحيح، هذا الاعتقاد غير صحيح، ويسير على خلافه القضاء في دولة الإمارات. فالقضاء الجزائي هنا في دولة الإمارات يسير عكس ذلك، وعرضت أكثر من قضية دفع فيها بعدم اختصاص القضاء بنظر الجرائم الرياضية، وتم رفض هذا الدفع سواء من محكمة أول درجة أو المحكمة الاستئنافية، وحتى محكمة النقد رفضت هذا تماما. وعرض نفس الأمر أيضا في مصر ودفع بذات الدفع، وكان أمام المحكمة الاقتصادية في قضية تتعلق باحتكار بث مباريات كرة القدم، والمحكمة رفضت وتم تأييد هذا الحكم في الاستئناف وفي النقد. وأيضا محكمة النقد في أكثر من مرة، محكمة النقد المصرية رفضت أيضا التعويل على الدفع بعدم اختصاصها. في النهاية، من خلال العرض الموجز جدا بسبب ضيق الوقت لتأمين المؤسسات والأنشطة الرياضية، يبدو لنا أن المشرع الإماراتي قد أحسن بإصداره القانون الاتحادي رقم 8 لسنة 2014 في شأن أمن المنشآت والفعاليات الرياضية، وهو الأمر الذي يدل على حرصه على ممارسة الرياضة دون أن يعكر صفوها أي أفعال تنطوي على الإخلال بالنظام أو الانضباط الواجب توافره في النشاط الرياضي. هو تشريع وقائي وعقابي في ذات الوقت، بحيث تضمن العديد من الإجراءات الاحترازية التي تحول دون الإخلال بالانضباط والنظام، كما تضمن عقوبات جنائية وجزاءات إدارية في حالة وقوع الجريمة أو مخالفة. ولم يعول هذا القانون بصفة أساسية على مأمور الضبط القضائي في تأمين الفعاليات والمنشآت الرياضية، بخلاف القانون رقم 15 لسنة 2005 في شأن تنظيم المشاركة في سباقات الهجن، والمرسوم بقانون اتحادي 7 لسنة 2008 في شأن الهيئة العامة لرعاية الشباب والرياضة والجهات العاملة، والقانون الاتحادي رقم 7 لسنة 2015 في شأن مكافحة المواد المحظورة في مجال رياضة سباقات الخيل والفروسية. وإن كان لم يغفل دور مأمور الضبط القضائي في الإشراف والرقابة والتوجيه والمساعدة لشركات الأمن الخاصة التي لها الدور الأساسي في هذا. ومن خلال ما تقدم أنتهي إلى 4 توصيات. إصدار قانون موحد للرياضة يضم جميع التشريعات المتناثرة ليجمع بينهم مدونة واحدة، مما يسهل الاطلاع عليها ودراستها، ويتضمن كافة الأحكام الموضوعية والإجرائية المتعلقة بالجرائم الرياضية. التوصية الثانية، وهي وإن كانت لا تتعلق بالتشريع الإماراتي إلا أنها تتعلق ببعض التشريعات المقارنة، وهو النص على الضبطية القضائية الخاصة في الجرائم الرياضية لما للتخصص في هذا الشأن من فوائد جمة، بحيث يتولى مرحلة جمع الاستدلالات في الجرائم الرياضية، وهو ما أخذ به المشرع الإماراتي. وأدعو التشريعات المقارنة إلى أن حذو المشرع الإماراتي في هذا الشأن. التوصية الثالثة تخصيص نيابة للجرائم الرياضية على غرار ما هو موجود في دائرة قضاء ابوظبي من نيابة الأموال ونيابة السياحة ونيابة البلدية وغيرها من النيابات، تتولى التحقيق والتصرف في الجرائم الرياضية، وعلى أن يتمتع أعضائها بتكوين فني خاص وخبرة عملية تكفل لهم مباشرة التحقيق والتصرف في الجرائم المذكورة. وأخيرا، حتى يستكمل التخصص في الجرائم الرياضية حلقاته، ينتهي بإنشاء محكمة رياضية تتولى الفصل في المنازعات الرياضية الجنائية لما يحققه التخصص من منافع عديدة في هذا الشأن، ولعدم خضوع الجرائم الجنائية المتعلقة بالرياضة للتحكيم الرياضي، بعكس المجالات الأخرى في المسائل المدنية والتجارية. وشكرا جزيلا، بشكر حضراتكم جميعا.
Thank you so much, Dr. Mohammed Smear. That was extremely interesting. Our next speaker, I'm excited to introduce you, as he actually was my lecturer at university. This is Mr. Tony Story. He taught at Northumbria University School of Law since 1994, mainly teaching and researching in criminal law and EU law. After supervising a number of students' dissertations on the role of criminal law and EU law in a sporting context, he designed a sports law class for the LLB program at Northumbria University. This started in 2012, and it's now in its 9th year and attracts a significant number of undergraduate students. Tony's going to talk to us today about doping in sport and analysis of historic decisions. Welcome.
Right, well, thank you very much, Chloe, and obviously thank you to the Abu Dhabi Judicial Department. It's actually a beautiful winter morning in the north of England, Chloe, you'll be pleased to hear. So yes, I'm going to talk to you about doping. Now, I do have a presentation, so hopefully I will be able to get this to work. Now then, just bear with me a minute. Right, where is it? I can't actually see it on my screen. Just bear with me. Well, I did have a presentation. I'm looking at it now, but I can't see it. That's not it. What can you see on the screen right now?
We can see your folder with the file in, so maybe if you try and click on it.
Okay. Not sure what's happening here.
No, it's not moving. I think you need to end the screen sharing. If you like, I can try to share it from my side and you can just tell me when to move on.
Right, okay, well, we can do that.
I'll try.
Let's see, missing controls. All right, okay. So yes, I'm going to look at some historic decisions in the context of history of doping. So if we can, excellent, yeah, so if we can move on to the next screen. What I'm going to focus on, given the amount of time at our disposal, is one provision of the World Anti-Doping Code. This is Article 10.4. Now it says that if an athlete or other person establishes in an individual case that he or she bears no fault or negligence, then the otherwise applicable period of ineligibility shall be eliminated. What we're dealing with here is situations where athletes have typically tested positive for a prohibited substance, which incurs a maximum of 4 years ineligibility depending on the substance. However, if the athlete can demonstrate that he or she bears no fault or negligence, then there is no period of ineligibility. I must stress it says no fault or negligence. So there is a high threshold for the athlete to cross over to succeed with this provision. Okay, can we move on? So I'm going to start just looking at some basic general principles. Again, if we move on. So I'm starting with a case from 2004 involving an American athlete called Torrey Edwards. We'll look at the facts of this case very shortly, but here the Court of Arbitration for Sport, CAS, said that there is an obligation and a duty on an elite athlete to ensure that no prohibited substance enters his or her body, tissues, or fluid. So an obligation and a duty on elite athletes. So that's the starting point. Right, next slide. In the 2006 case of Cecil Karatancheva, the Court of Arbitration for Sport said that mere protestations of innocence and disavowal of motive or opportunity by a player, however persuasively asserted, will not serve to engage these provisions. The Court of Arbitration for Sport has insisted that athletes provide evidence to the tribunal or the court dealing with the matter. So simply declaring your innocence or stating that you lack any motive or opportunity does not engage Article 10.4. The Karatancheva case was 14 years ago, but though that statement of principle there was declared redeclared just last month in the Andrea Iannoni case in November 2020, which the case will return to right at the end of the presentation. Okay, next slide. So sticking with the Karatancheva case, the athlete in this case was a 15-year-old Bulgarian tennis player who tested positive for a banned substance. And amongst her arguments was one that she was only a teenager and therefore should be given benefit on that basis. But the CAS rejected that argument, saying there is no automatic exception based on age, because such an exception would not only potentially cause unequal treatment of athletes, but could also put in peril the whole framework and logic of anti-doping rules. So if you're an athlete at a sufficient level of excellence, then you are expected to comply with all of the world anti-doping rules, and there is no exemption based on age. All right, next slide, please. So now we're going to have a look at just 2 or 3 unsuccessful cases. There are actually hundreds, or certainly dozens of unsuccessful cases. So I've just selected some of the unsuccessful cases, starting with Jason Keiter, an American rugby player who was playing for an English league, English rugby club. And one night he went out and got drunk with his teammates and accepted drinks from strangers in a bar. Now, alcohol is not a prohibited substance, but cocaine is. And one of the drinks that Mr. Keiter drank had cocaine in it. But the CAS said that that was not sufficient for Mr. Keiter to rely on the provision allowing for no fault. The court said that getting drunk and possibly not realizing and or remembering what was going on was an element of fault. Indeed, quite a high level of fault, and certainly not no fault. so Keiter was unsuccessful. Next slide. We have the cases of Cesar Cielo and others, several Brazilian swimmers who all tested positive for a prohibited substance. They'd all taken caffeine capsules to boost their energy during training. And these capsules had been contaminated with a prohibited substance. Caffeine is not prohibited, but a substance had somehow contaminated the caffeine supplements. This was completely unknown to the swimmers. However, the Court of Arbitration for Sport said that some fault or negligence has to be found to exist whenever an athlete uses a contaminated or mislabeled supplement. Emphasize the word supplement. As we shall see shortly, different principles apply if it's medication. So just to summarize, the unsuccessful cases typically involve eating or drinking something without checking its ingredients. We've just seen the Jason Keiter case there. But back to Tori Edwards, she tested positive for a banned substance, having taken glucose tablets that had been bought by a member of her entourage while she was participating in a sports meeting on the island of Martinique. But neither Ms. Edwards nor any of her team checked the ingredients, and had they done so, they would have discovered there was a prohibited substance in the tablets. More recently, Paulo Guerrero, the captain or then captain of the Peruvian national football team, tested positive for a metabolite of cocaine, which entered his system having drunk tea in a Peruvian hotel. The tea was contaminated with coca leaf extracts. So eating or drinking something without checking its ingredients constitutes fault. Not necessarily a high degree of fault, but some fault. So let's now move on to successful cases. And here we have 3 examples, starting with the case of Alexander Pobyedonetsov, who tested positive for a prohibited substance, but the Court of Arbitration for Sport allowed him to rely on the no fault provision because the substance was administered to him whilst he was in a Belarusian hospital receiving emergency medical treatment. He'd suffered an acute heart attack as a result of an on-ice incident whilst playing ice hockey for in Belarus. So medical emergency where the athlete has no understanding or appreciation of what is happening to them is clearly an example of no fault. In the Jeff Adams case, the athlete here, a Canadian wheelchair athlete, tested positive for cocaine. Cass accepted that the cocaine was in his system because he'd fallen asleep whilst in a bar in Toronto in Canada, and an unknown person had rubbed cocaine on his lips whilst he was asleep. The Cass accepted that was a form of a criminal assault on Mr. Adams, for which he bore no fault or negligence. And finally, on this screen, we have the case of Charlene Van Schnick from Belgium. Now, she was participating in the Judo World Championships in Brazil in 2013, and apparently her drink was sabotaged. Now, crucially, it was by a malicious third party, as the Cass described it. Sabotage by a member of the athlete's family or their own entourage would not meet the requirements of the no fault provision. But in the Van Schnick case, it was a malicious third party, and Cass accepted that that was no fault. Next, we have contaminated tap water. Jack Burke, a Canadian cyclist, and Kristen Schaldebin, an American gymnast, both tested positive for prohibited substances. The same substance, coincidentally, in each case, and apparently that was due to contaminated tap water. I should point out that the Kristen Schaldebin case was a decision of the United States anti-doping agency, USADA, and there's several more cases decided by USADA coming up in the presentation. In the Gabriel da Silva Santos case earlier this year, the Court of Arbitration for Sport accepted that when Mr. da Silva Santos shared a bathroom towel with his brother, and was inadvertently led to ingest a banned substance because his brother was using a cream containing this substance that Mr. Da Silva Santos bore no fault or negligence for that event. So contaminated tap water and a contaminated bathroom towel do not amount to fault or negligence. Next slide.
You see the next slide?
Yes, please. Yes, thank you, Chloe.
It should be on now. Successful cases.
I've still got the contaminated tap water and the towel cases.
It's not working?
No.
No, still not? Okay.
If I can try anything from my end.
It's showing on my screen, so I'm not sure why.
Ah, right. That's excellent. So it's back to where we were. So next we have 4 cases, all involving the same substance, meldonium. Now, meldonium was added to the prohibited substance list in January 2016. I should point out that the World Anti-Doping Agency updates its prohibited substance list every 12 months, and it's always on the 1st of January every year. The first 3 cases on the slide there, Olga Abramova, Maxwell Holt, and Nikita Lobintsev, all tested positive for meldonium during 2016, which was obviously after the substance was added to the substance list. But the evidence indicated that all 3 athletes had stopped taking the substance before New Year's Eve on 2015, and there was still trace elements of the substance in their system several months later. And the Court of Arbitration for Sport said that that was not fault in the Abramova case, and the US Anti-Doping Agency said the same thing in Holt and Lobintsev. Contrast with the Maria Sharapova case, the Russian tennis player who had continued to take meldonium after it was added to the banned substance list, and that did amount to fault on her part. So it must be prior to the substance being included on the prohibited substance list in order to benefit from the no fault provision. Next slide. Now here we have 5 decisions of the US Anti-Doping Agency, all involving the ingestion of a substance as a result of taking a contaminated medication. So we have the cases of Alex Kleinman, Grace Ariola, Stacey Manella, Chelsea McClammer, and most recently Jamie Brown, all of which tested positive for various prohibited substances. But in all 5 cases, the US Anti-Doping Agency said that the ingestion was a result of them taking medication which had been contaminated with a prohibited substance. We're still showing one of the old slides. I don't know if we can move on.
Yeah, it's just a technical issue, that's all. It's on my screen as the next slide. Can you see it? Successful cases, kissing.
No, that should be the slide that's up next, but it's not showing on my screen.
Okay.
Oh, we've just done that one, so we want the one after that.
I think it's just a technical issue, Tony. Is there any way you can continue without
Yes, sure. The next slide it deals with 3 cases involving kissing. Back in 2009, the French tennis player Richard Gasquet tested positive for cocaine, but Cass accepted that this was a result of him kissing a woman in a Miami nightclub. She had taken cocaine and he ingested it as a result of kissing her. That was followed more recently by the Canadian Sport Dispute Resolution Centre in a case called Sean Barber, who had kissed a woman in a hotel room. And most recently, an American athlete called Gil Roberts tested positive for a banned substance, which entered his system after he apparently kissed his girlfriend, who had been taking medication for a sinus infection. Even more recently, earlier this year, the US Anti-Doping Agency accepted that the no-fault provision was available to 2 American athletes, a boxer called Ginny Fuchs and a softball player called Madeline Nichols, both of whom ingested a prohibited substance as a result of sexual intercourse with their boyfriends. And the US Anti-Doping Agency said that that was something that had happened without any fault on Ms. Fuchs or Ms. Nichols' part. And finally, we get to contaminated meat. Now, this is, I think, the most controversial aspect of this particular subject area. The US Anti-Doping Agency has accepted that meat consumed by an athlete either in China or in Mexico can support the no-fault provision, because certain substances, in particular a substance called clenbuterol, is widely known to be used in cattle farming in both China and Mexico. So a number of athletes, including Jinglang Li, Guan Yu Ning, Augusto Montano, Brandon Moreno, and an American athlete called Will Clay, were all given the no-fault provision because they'd eaten meat whilst in China or Mexico. More controversially is when meat is consumed in other countries where the use of a substance is not necessarily so well known. But in 2017, the US Anti-Doping Agency accepted that a sprinter called R.G. Wilson had eaten contaminated meat in a New York restaurant. In March this year, CAS accepted another American athlete called Jarian Lawson had eaten contaminated meat in an American restaurant in Arkansas, and accepted that he had acted with no fault or negligence. More recently, still in July of this year, a Canadian athlete called Dominika Jamnicki was given the benefit of the no-fault provision. She had eaten contaminated meat either in Australia or Canada. She was unable to pinpoint exactly where she'd eaten it, but the Court of Arbitration for Sport accepted it must have been in one of those 2 countries, and therefore she'd acted without fault. And most recently, this was earlier this year, last month, an Italian motorcyclist called Andrea Iannoni tested positive for a banned substance. He claimed that he'd eaten contaminated meat either in a hotel or in a restaurant in Malaysia, but CAS said that he'd acted with fault and in fact increased his ban to 4 years because he'd failed to establish which meat he'd consumed or where exactly he'd eaten it. And he'd also failed to establish that the particular substance was even an issue in Malaysian farming. Which just goes to show that as far as contaminated meat is concerned, it depends on what the substance is, where it was consumed, when it was consumed, and each case has to be decided on its own individual facts. There we are. Apologies for all of the technical issues during that. I hope that made some sense.
Okay, thank you so much, Tony, for that. Okay, now we move on to our final speaker, Mr. Ulrich Haas. He is a professor of procedural and private law at the University of Zurich. He is also of counsel in the law firm Times Attorney in Zurich. As an expert researcher and practitioner in the field of sports law, he regularly acts as arbitrator with, among others, the Court of Arbitration for Sport. In 2018, he was appointed president of the Basketball Arbitral Tribunal. He also served as a member of the WADA Code project team that drafted the WADC 2015 and the WADC 2021. More recently, he chaired the WADA Working Group on Governance. Furthermore, Professor Haas does extensive consultative work as well as legal opinions in the field of sports law for national and international federations, clubs, and athletes. He will be addressing the topic, an overview of the New World Anti-Doping Code. Welcome.
Chloe, thank you very much for your very kind introduction. Can you hear me and see me?
Yes.
Wonderful. Thank you very much. And let me extend my gratitude and very warm regards to the Abu Dhabi Judicial Department for organizing this. It's a great honor and pleasure for me to be here with you. Now, what I will be doing in the couple of minutes that for my presentation, I will talk about the World Anti-Doping Code. And as you can see, this legal framework will come into force in 2021. That is on the 1st January of 2021. The regulatory framework has been accepted at the World Conference on Anti-Doping in Katowice in November 2019. All stakeholders, especially the signatories, had about a year time to implement these new provisions. And I'm trying to give you a very short overview of
أنا آسف جدا الصوت منخفض بعد إذن حضرتك أستاذة فاتن. الصوت منخفض جدا.
Okay, so
كده أحسن فعلا أشكرك.
I'll try to give an overview of the most prominent changes. Now, this is not the first revision of the World Anti-Doping Code. Actually, we're in the fourth revision process. Everything started in 2003, and the interesting thing is actually that every revision process has its own theme. So it has a driving engine which really overshadows the respective revision process. So in 2003, when everything started, it was the wish to harmonize things, which was a big task at the time because we had plenty of different rules around with the international federations, and to try to come to a common denominator was actually quite challenging. In the second revision process, I think the stakeholders realized that there is not just one size fits all. So what people were looking for in the second revision process was actually to get more proportionality in the system. And if I say proportionality, what people were looking for in particular was more proportionality when it comes to the sanctioning scheme. And then in 2015, everything I think was driven by the Armstrong scandal. So shortly before this revision process, the Armstrong scandal erupted, and people thought we have to make sure that something like the Armstrong scandal is never going to happen before. So intel gathering was improved. Athlete support personnel were targeted and focused much better than before. And of course, the sanctioning scheme changed quite dramatically because there was a shift from a standard 2-year sanction to a 4-year sanction. And then 2021, probably the driving theme of the 2021 revision process is probably the Russian doping scandal. A lot of new provisions were introduced to make sure that something like the Russian doping scandal is not going to happen before. Now, commonly, they're not really super dramatic changes from the 2015 code because stakeholders said that the 2015 code had worked well. Everybody was used to it. Everybody appreciated what we had. Of course, a couple of things needed to be changed, but overall, stakeholders thought that the existing code was working well. And people that engaged in the fourth revision process were more, I would say, people from the field, practical application. This was what was at the center and the focus of the fourth revision process. Now, as always, people want to have it as harmonized and as detailed as possible, but at the same time, of course, they want to have a lean text, little complexity, and of course these two goals are very hard to harmonize with each other. Now, if we look at the complexity, it is actually true that the new World Anti-Doping Code is shorter than the one before. The main reason is that a lot of things have been shifted from the text in the World Anti-Doping Code into international standards. Now, this makes the World Anti-Doping Code a little bit more readable, but on the other hand, of course, complexity rises because you have different texts that you need to consult in order to decide on a case. In particular, two new international standards have been added. This is the International Standard for Education and the International Standard for Results Management. In addition to that, a new text was enacted as well. It's the Athletes Anti-Doping Rights Act. It is not a mandatory text. What the Athletes Anti-Doping Rights Act seeks to do is actually to put at one spot, which is in that act, they try to put every provision that is important to athletes in the context of anti-doping. Now, looking at additions to the World Anti-Doping Code that have been enacted in 2021, I would say the big topics are probably the following. First of all, what we do see in the world of anti-doping is that we get more and more professional contractors that do the work for anti-doping agencies or for international federations. And of course, one has to set a legal framework for these service providers, in particular for the ITA, the International Testing Authority. So quite a few rules try to tackle that issue. As I said, there have been two big scandals, the IAAF scandal and the Russian doping scandal, that were at the origin and the driving force for the 2021 code. So quite a few provisions try to tackle that, starting, of course, with the compliance provisions and ending with new anti-doping rule violation provisions that have been enacted. Big topic, and I think it has been addressed already a little bit by Professor Story. He talked about lots of cases involving substances of abuse. It is unfortunate, but athletes, or a lot of athletes, tend to take those substances of abuse. And the question really is, how do we tackle with those substances of abuse in a meaningful manner in the context of anti-doping? And new provisions have been enacted to give a more fair and just approach to those substances of abuse. And finally, and this again has been tackled already a little bit by Professor Story, is the question of contaminated products. In particular, what we're struggling with at the moment are meat contamination cases. Laboratories get better and better. They are able to detect the smallest amounts of quantities. And of course, the better these analyses get, the smaller the quantities that you can detect, the more risk there is that there is cross-contamination with some other products. And of course, things have to be or need to be addressed in this context, and the code try to tackle this this big issue of contaminating products. Now, of course, and this has remained the same, all these levels that you find in the World Anti-Doping Program are mandatory in character. However, and I think this is a very helpful comment that we do find in the new World Anti-Doping Code, is that, of course, the code tries to establish a level playing field, but the signatories are not prevented from enacting safety, medical, or eligibility rules that, of course, go beyond those rules that you would find in the code. This, of course, is perfectly admissible and would not breach the mandatory character of the World Anti-Doping Code. Finally, I won't go through step by step all of these things, but what is important to understand is that the new World Anti-Doping Code has added a lot of flexibility when it comes to the sanctioning system. Yeah, there are lots of new provisions adding flexibility to go down from the standard period of eligibility of 4 years. The most important one has been addressed already, the substances of abuse. And of course, there are quite a few provisions also that allow for increasing the sanctions, so also flexibility to increase the sanctions. Probably the most important provision that we would find in the new code is a provision dealing with aggravating circumstances where you can add another 2 years to the standard period of eligibility of 4 years. So a lot more flexibility when it comes to the sanctioning system. And finally, the last slide that I want to show you is, from my perspective, a very important change that has been enacted in Article 15 of the World Anti-Doping Code, which has remained so far a little bit under the radar. The underlying idea today is that every signatory around the world applies the same rules. And if that's the case, I think there's also room for more trust if decisions are enacted by different signatories around the world. Now, in the past, the situation has been like this, that if a signatory, for example, an international federation, has enacted a decision in the context of anti-doping, in principle, that decision would only cover its territory, its sport. Another international federation would have the power to review that decision and decide whether or not to recognize such decision for its own sphere of competence. Now, this changes dramatically with the 2021 code. Now, the situation is going to be like this. Since we're all applying the same rules, once the signatory has taken a decision in an anti-doping matter, these decisions, ex officio and erga omnes, will deploy their effects around the world. So a really transnational recognition mechanism that we find here in the new World Anti-Doping Code. Well, these would be my presentation for today. Thank you very much for your attention. It has been a great pleasure talking to you. And of course, if there are any questions, I'm here to answer them. Thank you very much. And I hand back to you, Chloe. Thanks a lot.
Thank you very much, Mr. Hess. That was a fantastic presentation. It's an honour to have you with us today. We have now actually heard from all of our speakers for today. Thank you all for attending. You've done an amazing job, and you've all discussed some really interesting points of law. What we will do now is we will go through the questions that we have in the question and answers. Some of the speakers aren't able to stay longer than the this time, but there are some remaining and they will be available to answer. So the first question is, how did COVID-19 change the proceedings and the volume of sports law cases? And that's open to any of our speakers.
Chloe, if you don't mind, I just jump in, if that's okay.
Thank you.
So I'm a case arbitrator as well, so I have a pretty good overview of what the caseload is at the moment, and it is actually quite surprising. First of all, I think there are more cases now in the COVID-19 pandemic, and the reason is, as soon as money gets scarce, people will fight much more on claims as they used to do before, so less settlements between the stakeholders in sport. And the second interesting thing is that, of course, it's much easier to organize a video hearing at CAS than it is to have an in-person hearing. Now, if you have an in-person hearing, people will tell you that they're only available 4 months from now because they will be traveling all over the world. And now things have changed dramatically. You can schedule a hearing in 2 weeks from now because most of the people will not be traveling. So I think the amount of hearings that we had at CAS exceeds everything that we have seen so far. So a lot of more cases and a lot of more cases that are being dealt with at the Court of Arbitration for Sport.
هل الترجمة غير متوفرة؟
Sure. So what I've been saying is that the caseload, from my perspective, has increased dramatically at the Court of Arbitration for Sport. First of all, because people tend to fight much more in case money is scarce. Yeah. So if the resources are scarce, people will fight over every single penny. And this has led to a lot of more cases at the moment than in the past, much less settlements that we used to have. And secondly, it is much easier now to schedule a hearing on video at the Court of Arbitration for Sport, as it has been in the past when you practically had in-person hearings only, because the parties, the lawyers, the witnesses, the experts will not, or are difficultly available on a sole day. And now things have changed very much because nobody is traveling, and you can schedule a video hearing in 2 weeks from now without any problems whatsoever. Thank you very much.
Thank you very much. Okay, the next question, this is probably for Dr. Mohammed Samir. Is the security zone defined by UAE law before arriving at the stadium in which any act of violence will be the responsibility of the organizing club? And we need the English translation. Yeah, if you can remain in the English channel and Asif remains in the Arabic channel, that would be best. And this is for Dr. Mohammed Samir. Is the security zone defined by UAE law before arriving at the stadium in which any act of violence will be the responsibility of the organizing club?
Please translation.
Is this
translation?
Okay, excellent. Is the security zone defined by UAE law before arriving at the stadium in which any act of violence will be the responsibility of the organizing club?
المسؤولية هي ضابط أمن الفاعلية وضابط أمن المنشأة، الاثنين معا، ودول بيكونوا المسؤولين عن التأمين، وبيكونوا من شركات الأمن المسؤولين عن التأمين، لكن الإشراف والتوجيه بيكون من مراقب الشرطة. مراقب الشرطة من الجهة الشرطية المختصة داخل الإمارة أو من وزارة الداخلية. إنما هو دوره الإشراف والرقابة والتوجيه. ممكن يضع لهم، يساعدهم في وضع خطط التأمين، ممكن هو اللي يضع لهم خطط التأمين، لكن كتنفيذ للتأمين والظهور ومباشرته من الناحية الفعلية، من يباشر هذا هو ضابط أمن المنشأة وضابط أمن الفاعلية معا. إنما دور مراقب الشرطة بيكون التوجيه والإشراف، فضلا عن أنه في حالة وجود تقصير بيتم المؤاخذة لشركة الأمن الخاصة. شركة الأمن الخاصة بيمثلها أو المسؤول عن التأمين فيما يتعلق بها ضابط أمن المنشأة وضابط أمن الفاعلية. إذا كان هناك أمر آخر
Yes.
يعني غير واضح مستعد لتوضيحه.
Thank you. I think that's the end. So the next question, this one is addressed to Tony Story. How essential is it to have sports law courses in universities during bachelor years, rather than having a specialized master's degree on the subject? And in your opinion, what are the characteristics that would make a certain subject of law teachable during bachelor degrees years?
Well, the first question about how essential it is, it's actually, I think sports law is relatively rare in English law schools. I get the impression it's a lot more common in American law schools, certainly because I refer to a lot of American specialist journals that are devoted to either sports law on their own or entertainment and sports law. There's very little like that in England. There are some dedicated legal sports law journals in England, but I think that reflects the fact that it's not a big subject in English law schools currently. I think there's at least one English university that does offer a master's degree. I think that's Nottingham Trent University, I believe. But there's currently only, I think, a handful of English law schools that offer a sports law module. What was the second half of that question, Chloe?
The second one was, what characteristics makes a certain subject of law teachable during the bachelor years?
Oof, wow. Well, that is a good question. I'm not quite sure what the answer to that one is.
I guess we could reword it and say, what made you draft the sports law program as opposed to an alternative area of law?
Right. Well, the answer to that is because at the university where I work, it was and it remains compulsory for students in their final year to write a dissertation on a legal subject of their choosing. And throughout the 1990s and the early years of this century, I noticed that a lot of students were choosing to either look at the Bosman ruling, which of December 1995, which was very important, and lots of students who were interested in sport in general and football in particular wanted to research it and discuss its implications. And because I taught EU law at the time, I often ended up supervising these projects. And other students, meanwhile, were interested in the potential criminal or civil liability for sports injuries, typically in football or rugby or ice hockey. And over a period of years, I eventually came to the conclusion that there was an unmet demand for students who wanted to study the law relating to sport. So eventually, about 10 years ago now, I did some research and found that a number of barristers' chambers in England were specializing in sports law, and some, not many, but certainly some legal firms, particularly in London, and also in the northwest of England, which is if you're not familiar with England, it's a bit of a sporting zone of excellence, because you've got the two big Manchester clubs, you've got the two big Liverpool clubs, you've got Lancashire cricket, Canby cricket team, various rugby league teams are all based there. So Manchester is a bit of a sports law area of expertise. So I thought there's obviously a demand amongst the students, and there is the potential for legal careers as well. So I did some research and pulled together a syllabus which covered things like the aforementioned Bosman ruling and liability for injuries, and added in things that we've already talked about today, like doping and football hooliganism, and other issues like ticket touting, restraint of trade in sport, liability for stadium disasters, things about liability for nuisance, which is typically where someone who lives near to a sports stadium complains about the noise or light or other disturbance. And so the module grew very quickly out of all that, and it actually ran as a full year-long module. So students studied it from September to May we've now only got half of that time available. So I've had to streamline the syllabus, but it's something which it's got I think the perfect combination of academic interest and also practicality. So I suppose that is the answer to the question, really. If a module has sufficient academic interest to get students engaged with discussion about the legal issues, but it also is something that can be put to use in practice, I think that's the perfect combination.
Okay, excellent. Thank you very much. The next question is for Mr. Haas. As a CAS arbitrator, what is your opinion on increasing the eligibility ban from 2 years to 4 years for the first breach of the WADA code?
Thank you very much for this question, and it is an interesting question, because if we look back at 2003, is the translation okay?
Yes, it should be fine. Thank you.
Okay, so if we look back at in 2003, the standard period of eligibility has been 2 years. Now, if we look at the 2021 code, the standard sanction is 4 years, but you can increase the standard sanction by another 2 years to up to 6 years. So the difference actually from 2003 to 2021 is quite dramatic, from 2 years up to 6 years. Now, my personal opinion is that, well, there are a lot of people that think that combating certain misbehavior in sport, the best thing that you can put in place, and the only thing that you should put in place, is deterrence. I wonder really whether this is the case. I had the privilege to have CAS proceedings with quite a few of these high-profile athletes, and I had also the chance to interview at one point in time Lance Armstrong, and then my question to him was, well, would things have changed if the sanction at the time would have been 8 years or 10 years? Would you have engaged in different behavior in doing that? And the surprising answer, of course, is from all these athletes is nothing would have changed. So I think we should make sure, of course, there has to be a working deterrence in place. But if you want to be effective at the end of the day, combating those misbehaviors in sport, including doping, I think you have to look at a lot of different issues than only deterrence. Yeah, and I think it was also a good idea in the new World Anti-Doping Code to insert a new international standard for education, because there needs to be something in addition to sanctioning in order to be effective. Thank you.
Thank you very much. So we, sorry.
انت بتاع محطوط، لازم ما تعرفش تلعب في الكلام ازاي تختصر كده. ما حاولتش.
Okay. The next question is for Dr. Mohammed Sami again. So Fatin, if you could kindly translate to him. Is there an objective criteria to define the security area? For example,
الدكتور محمد سمير هيرد من خلال عندي أنا، عشان هو موجود معايا.
Okay, I'll repeat the question so you can hear me. Is there an objective criteria to define the security area, for example, 800 meters around the stadium, like South America Code 2018, or does it depend on a case-by-case basis? Oh, it appears that he has left the call. If anybody else, any of the other speakers would like to
طبعا في معايير امنيه وضعتها اللائحه التنفيذيه للقانون الاتحادي رقم 8 لسنه 2014 بشان المنشآت والفعاليات الرياضيه، والمعايير دي بينتها بالتفصيل يعني على وجه دقيق جدا اللائحه التنفيذيه. لكن يعني مساله نتناولها بالتفصيل يعني هيحتاج وقت طويل جدا، لكن ابرزها انه لابد من التنظيم زي ما باين القانون انه لا يقتصر فقط على المكان اللي بتجرى فيه الفعاليه، لا ده بيكون في مسافات حول الفعاليه بيتم تامينها وتامين. نعم؟ لا كمسافات بالكيلومتر مفيش معايير، مفيش تحديد يعني مسافات محدده، انما هو القانون واللائحه نصوا على انه يجب التامين ان هو لا يقتصر فقط على المكان اللي بتجرى فيه الفاعليه، وانما الاماكن المحيطه به والطرق المؤديه اليه. فده هيختلف بحسب كل مكان، يعني المشرع لم يحدد مثلا مساحه 3 كيلو متر 5 كيلو متر 10 كيلو متر، ما حددهاش، لان ممكن الفعاليه دي تكون في مكان محدد يختلف عن مكان اخر اللي بيقتضي مساله التامين مساحه اكبر بحسب اختلاف المكان. فلم يضع المشرع الاماراتي مسافات محدده، انما وضع قواعد عامه اللي هي انا بامن المكان وما يحيط به من سياج وما يؤدي اليه من طرق توصل اليه. فهذا يختلف من مكان تقام فيه الفعاليه لمكان اخر، يعني لو كان مثلا على سبيل المثال في استاد الوحده، الطرق المؤديه الى هذا المكان هتختلف عما اذا كان اجري في مكان اخر مثلا في بنياس. فالامر بيختلف لاختلاف الامكنه التي يجرى فيها الفعاليه الرياضيه، انما لم يحدد المشرع مسافات محدده، وانما ترك هذه الامور الى الجهه القائمه بالتامين، وهي زي ما ذكرت سلفا هي ضابط امن المنشاه وضابط امن الفعاليه، ودول بيمثلوا الشركات الخاصه المسؤوله عن التامين تحت اشراف وتوجيه ورقابه الشرطه.
Thank you, Asif. Have we finished? Okay, excellent. Thank you so much. And that was a great response. The next question is for everybody. What is the difference between managing and controlling the activities from a legal perspective?
الفرق بين إدارة الفعالية وضبطها.
الإدارة هي ما يتعلق بالسيطرة على التأمين، من هو الذي يحدد كيفية إجراء التأمين ويضع الخطة اللازمة لإجراء هذا التأمين.
والضبط.
إنما
الضبط هو اللي بينفذ.
ضبط الفعالية يعني زي ما أنا ضربت مثال مثلا إنه الشرطة هي اللي بتوجه ضابط امن المنشاه وضابط امن الفاعليه وتضع لهم خطط التامين اللازمه، فالاداره بتكون للشرطه، انما الضبط بينفذه شركه الامن الخاصه واللي بيمثلها ضابط امن الفاعليه وضابط امن المنشاه. وضابط امن الفاعليه وضابط امن المنشاه ليس كما يوحي اسمائهم ان هم ضباط من قبل الشرطه، لا هم ضباط من الامن الخاص وليس من الشرطه. فالاداره هي بتكون من الشرطه، انما الضبط والتنفيذ بيكون من شركات الامن الخاص.
Thank you very much. Okay, so the final question is regarding the issue of anabolic steroids. Why is there no doctor assigned by the Ministry of Health of each state residing inside every sport club to follow up all athletes?
I don't know if Ulrich can take that one. It's beyond my expertise, I'm afraid.
Well, of course, I would not be able to say something on all the individual jurisdictions around the world, but from a European perspective, especially if you look at the Council of Europe, they have made a survey, and actually it's quite interesting that nearly every single country in Europe that is member of the Council of Europe, they do have legislation in place whereby the moving, the bartering, the exchange of anabolic steroids in principle is forbidden. And quite interestingly, in some of these countries, there are quite elevated criminal sanctions in case that you breach these provisions of state law. And of course, police has to look after that, the prosecutor has to look after that. And in most countries also, either the Ministry of Interior, that normally is also responsible for sport, or a special sports minister will look after these issues. So there is, in a lot of countries, legislation in place that tries to dry up the market for these kinds of substances, in particular by imposing criminal sanctions on that. And this has reduced the traffic for anabolic steroids in these countries quite a bit.
هو إذا سمحت لي لو سمحت لي مس كلو، يعني أقول رأيي في هذه المسألة. هو رغم أن ليست هناك في القوانين ما يلزم بأن يكون هناك طبيب منصوص على وجود طبيب في كل منشأة رياضية أو في كل تجمع رياضي بيشترك في المنافسات على مستوى البطولة، إنما من الناحية الواقعية ومن خلال تجربتنا وعلاقتنا بالأجهزة الرياضية، سواء كنت أنا من قبل مشارك في إدارة أحد الأندية الكبرى في مصر مدة طويلة، واتصالي بالأنشطة الرياضية من حيث الإدارة فيها، فنتيجة لخطورة مسألة المنشطات، فكل المنتخبات القومية أعتقد وكل الأندية في مختلف بلاد العالم، نتيجة لأنها تعرف النتائج السلبية الكبيرة التي تظهر إذا ما ثبت أن أحد أفراد الفرق بيتناول منشطات، فالأندية والمنتخبات القومية على مستوى البلاد أو على مستوى الأندية في داخل أغلب البلاد، فهي حريصة على أنها تجنب اللاعبين أو المشاركين في البطولات أو في الممارسات الرياضية أنهم بيتلقوا أي منشطات أو أي عقاقير أو أدوية مدرجة على الجداول باعتبارها من المواد الممنوعة. فرغم عدم وجود ما يلزم فعلا بوجوب أو بإلزام بوجود طبيب، إنما من الناحية العملية فالأندية من خلال مشاركتها في البطولات والمنتخبات القومية من خلال مشاركتها في البطولات القارية أو الدولية أو المحلية حتى، فبتبقى حريصة على تجنب تناول هذه المنشطات لما تعرفه من الآثار السلبية الكبيرة نتيجة أن يكتشف شخص أنه أو لاعب أنه يتناول منشطات أو أدوية ممنوعة. فهو فعلا الإلزام مش أو غير منصوص عليه، إنما من الناحية العملية هو طبعا الجميع بيراعي أن يتجنب مسألة الاشتراك في المنشطات، تناول المنشطات. شكرا.
Thank you. It's really great to listen to both of your opinions. Thank you for sharing that with us. So we have now officially reached the end of the webinar. Sorry for keeping you so long, and apologies about any technical difficulties. Unfortunately, these things happen when we have to do virtual webinars. And I think we can all agree that if we've been able to, the translation has been excellent. Thank you so much for joining us. We do have day 2 tomorrow, which starts at 7 p.m. UAE time. I hope you can all join us then, and we talk about 6 other really interesting topics. And we also have a speech from His Excellency Dr. Abdul Majid, which is going to be very exciting. So yes, thank you for attending. Thank you so much to our speakers for taking time out to prepare and attend the presentation today. It's been excellent, and we hope that you can visit us in Abu Dhabi soon.
وانا تسمح لي مس قلوب ان انا باعتباري من المشاركين في هذه الندوة، فأنا بأشكر مس كلو على إدارتها لهذا اليوم بإدارة ناجحة. أشكر أيضا الترجمة وعلى رأسها مس فاتن، وبنشكر فعلا جميع المشاركين للاستفادة الكبيرة التي استفدناها من حضرات المشاركين بالكلمات. وبنشكر من قبل ومن بعد دائرة القضاء وسعادة يوسف العبري وسعادة أحمد المرزوقي على رعايتهم لهذا النشاط العلمي المتميز فعلا. شكرا لكم جميعا.
Yeah, thank you, Dr. Abdul Majid. I think we've covered everybody. Mr. Ahmed Al-Mazuri and also Mr. Faisal Al-Khoury, who is head of our sports law department. So thank you very much for attending. Please enjoy the rest of your day or evening or morning, and we hope to see you tomorrow in the webinar. Thank you.
Thank you. Goodbye.
Goodbye. Thank you.